784 of 2022.
Mention करो. Should allow them to mention first. All right. Oh.
Keeping abreast of the scope of intra-court appeal as propounded by Honorable Supreme Court as well as this court, for the reasons stated above and the discussions made in the foregoing paragraphs, no infirmity in the decision of the learned single judge by judgment dated 8/9/2021 is perceived, and therefore this court declines to show indulgence in the said judgment in this writ appeal. In the result, this writ appeal stands dismissed, but in the circumstances, there shall be no order as to costs.
I agree. In the wake of above-noted discussions, we reach the following definite conclusions. The respondents do not qualify to get the benefit of Odisha Civil Services Pension Rules 1992, given the unambiguous language of Rules 3, 11, and 13 of the said rules. The respondents cannot be treated to be the employees of government to qualify for pension under the Odisha Service Pension Rules 1992, the later dated 24/5/2017, based on which the impugned order has been issued, does not contain any decision of the state government to extend pensionary benefits to the directly appointed retired staff of ITDAs and micro projects. The purpose of the said communication has been mentioned in the letter itself, that is for necessary compilation of data at this level. In the result, we disagree with the view taken by the learned single judge in the order under appeal dated 2010-2022, passed in WPC OAC number 1126 of 2017, which is accordingly set aside. The appeal is allowed. Consequently, the writ petition stands dismissed. There shall be no orders as to costs. The application, it has become infectious. So the application stands disposed of accordingly.
Item number 4.
Yeah, please, Your Lordship. In this case, the writ petition was filed with a prayer challenging the counseling process for PG medical admission in 2022.
That is over.
In fact, in the meantime, I have filed an IA also at flag C, praying for withdrawal with liberty to because I want to claim compensation also. So I want to withdraw with liberty to approach the appropriate court.
And counsel for the petitioner seeks permission to
That
withdraw
is at flag C.
this writ application, as he admits that the relief is the petitioner has sought in the present application cannot be granted, as the admissions to the PG medical course, admissions to PG medical courses are over. Stop. He, however, submits that for the loss caused because of inaction oblique wrong action of the respondents. Full stop. The prisoner deserves to be appropriately compensated, for which he should be granted liberty to approach an appropriate forum as may be available to the petitioner. Also, this application is dismissed as withdrawn with the liberty as sought.
Published.
Item number 5.
Yeah, please, Your Lordship. Your Lordship, here the petitioner is has a proprietary firm in the name and style of MS Reliance Traders. The present opposite party is an Indian Oil and Gas Corporation.
My lord, already I have a third appearance. I'll file my counter already to extend my client.
So you are challenging the advertisement.
Your Lordship,
Where is that?
Annex 4,
Page?
page, Your Lordship.
It is there. Mr. 4 is there before us. So what is wrong with the advertisement?
Your Lordship, here, as per the agreement, Your Lordship, may kindly come to page 17. Your Lordship, here the contract agreement made on 3/2/2023 got renewed as per the renewal clause of the agreement year after year. And the latest contract agreement of SSR was executed
Agreement between whom?
between the Indian Oil and Gas Corporation and the stockist here. With that, the petitioner.
So
Your Lordship, here the agreement was between the tenure between the period is that from 27/2/2023 till 25/2/2026. So that is in page 4 of
this is for the same area. This advertisement is for the same area.
Your Lordship, the advertisement is for the new stockist to be for the area of the Jashpur Road. For the appointment of the area of the Jashpur.
And your appointment was for?
Your Lordship, same position as the stockist, harbor stockist.
Yes, why?
But I'll file a reply to that. In fact, Your Lordship, there is a clause in the arbitration agreement, the agreement between the parties, that further persons can also be appointed. So that clause has not been, perhaps has not been taken note of by my friend appearing for the petitioner. That is to brought to the notice of this honorable court. I'll file my agreement, a written note, written counter, also be disposed of. 2 weeks time may kindly be granted. I'll file my written counter.
Have you seen that?
Your Lordship,
Have you seen the counter affidavit?
Your Lordship. No, sir, Lordship.
Agreement. There's a clause in the agreement.
Your Lordship.
So agreement is referring to a clause.
The clause 52.
Where is that?
Your Lordship, here the clause 52 of the contract agreement says that without prejudice to any rights and remedies provided elsewhere in the agreement or otherwise in law, the foregoing provisions or anything to the contrary herein contained either of the parties hereunto, namely the corporation or so and so, shall be entitled to terminate this agreement on giving 3 months notice. Your Lordship, we have not got any notice.
No, where is the arbitration clause? He is referring to.
No, it's not arbitration clause. It is the clause that further DSRs can also be appointed in the same region.
Where is that? Which
Yours-
clause?
I'll file that in my counter. I've already sought for the instructions. I'll file it in my counter.
Requested on behalf of the opposite party number 1. So this two has been given.
Your Lordship.
I'm appearing for the opposite party, both the opposite parties.
Both the opposite party. How can you appear?
It has been assigned to me by the Government of India as well as I'm the counsel for Indian Oil Corporation.
There is only one opposite party.
There is only one opposite party.
See, it is Indian Oil Corporation. Union of India is also in party.
There is no Union of India party.
Indian Oil Corporation.
Only one party.
Let, as requested on behalf of the Indian Oil Corporation Limited, place this matter on 4 weeks so as to enable him to file.
Your Lordship, interim application maybe.
In the,
Already they have been appointed, my lord.
where is the question of interest?
Those facts are need to be brought to the
All
notice.
right, we'll see. 2 weeks, where your.
You also may
is ready.
keep it to next week also, I can file it.
Next week,
Any day next week.
1 week. All right.
Item number 6.
May it please, ma'am. The filling before your lordship assails the order of the Honorable Single Judge at page 85, passed in contempt, case number 1383 of 2017 minutes. The
No,
short,
which order you are challenging in this field?
I'm challenging 85, page 85, order.
Interim order. Interim order.
Interim order. This matter is taken up for hybrid on perusal of the affidavit filed by the opposite parties, number 2 and 3. This court does not find any satisfactory reply. This court is of the view that regularization of the services of the petitioner should have been done from the date of his joining the post, as he was appointed against a sanctioned post by way of a valid selection process. Hence, this court as well as the apex court have held in a catenary of decisions that regularization of services should be done from the date of joining, not from the date of judgment. The opposite parties, contemners, are directed to file an affidavit in the light of the above observation on or before the 20th February, so and so. Our contention before your lordship is this, my lord,
But
that,
why are you challenging this order? You can go and you can convince the court.
my lord, the
You can convince the court to two things, that the observation is contrary to the Supreme Court's decision, or this observation could not have been made in the concurrent proceeding.
my lord.
This is your submission.
My-
You can convince the
So-
court.
Well, I am armed with a direct decision of the Honorable Supreme Court.
You can, if there
Mal-
is a direct decision, then you can go, you should go there. Why should you challenge an interim
Well,
order?
this,
in intra-court?
my most humble and most respectful submission before your lordship is this, my lords. The moment, my lords, an observation, even in an interim order, is made on merits of a dispute, my lords, which decides the lease, or in some way, my lords, expands the lease in a writ petition, my lords, it becomes amenable to an inter-court appeal. Direct. Your lordship knows that judgment, my lords. I'll cite that judgment. Your lordship may kindly bear with me. Midnapur. judge was you either come with the order appointing him from way back 20 years back, or I'll ask the vice chancellor to appear in person. That was the observation. So I'm not passing any order, but this is. So therefore, my lords, in desperation, we asked him to crystallize the point. My lords, the point has been crystallized. This is the, my lords, the Judge Rashmi kindly.
But what was the direction of the court that was required to be carried out?
My lords, I'll just take your lordship to that. Grateful, my lords. Grateful. Your lordship may kindly come to paragraph, page, my lords, page 32 of my brief, my lords. The judgment of the Honorable Single Judge. My lords, what happened? The single judge's judgment, my lords, was passed on 1/12/2015, my lords. The matter was taken in appeal.
There is a system is High Court
My lords.
that if an order is passed by a particular judge of the court, then the contempt matter should normally go to the same court.
My lords, not necessarily, but not necessarily on the assignment. Now, my lords, it's earlier.
Here it was happening.
It was happening, but now it is-
Wherever the honorable court was passed that order, that should be placed before that bench. But now the
Now it-
assignment of the Chief Justice, Honorable Chief Justice can.
Their lordships have made some tweaked assignment saying that wherever the matters are listed, normally the contempts will go there on the available day. That is how your lordships have changed the system.
Not change, but this is
That's a
usually
new system.
your lordship's predecessors, so they have passed. But there is no such rule.
No such rule.
But precedents require that should be because the very same judge who has passed the. Yes, practice. That is the practice.
That is the old practice, and it's almost everywhere. Contempt matters are listed before the-
In fact, 80s, 90s, we remember, my lord, that was happening. That has to be placed before that bench, provided the judge has not retired. The honorable judge has not. Ordinarily. That was also in case of bails. He also knows that once a bail has been disposed of, that should be placed before that bench. That's normal procedure.
Or like review,
Right, sir.
the kind of add up.
Yes, sir. Yes, yes.
So this judgment, my lords, was carried in appeal. Appeal, my lords, it was stayed. Then it remained stayed for some time. Can we do that? No. My lords.
Where is the order?
My lords. Page 32. page 32 minutes, paragraph 22. Paragraph 21. No doubt, after establishment of BPUT, the institutions under the control of BPUT have to fill up the vacancies in accordance with the provisions of the BPUT Act and rules framed thereunder. If the institution had been taken over with along with the staff, in that case, BPUT has to take necessary steps for regularization of the services instead of terminating them, though the employees have not been appointed under the provisions of the BPUT Act and rules. In that view of the matter, this court is of the considered view that the opposite party should absorb the petitioners on regular basis against sanctioned vacant post, taking into account the length of service rendered by him as a lecturer in mathematics, in which he is continuing without insisting upon him to undergo the rigors of the selection procedure laid down under the BPUT Act and rules framed thereunder. Reason being, in the meantime, the petitioner has become overaged and he has also been exploited for 20 years for no reasons, though he has qualified in all the interviews conducted by the authorities.
So they have been absorbed.
He has been absorbed from the date of this judgment. Initially, this went up to Supreme Court. Initially, the appointment was given from the date of the Supreme Court judgment. Then, on a contempt application, the Honorable Court's view that no, you have to give it from the date of the single judge judgment. That has been done. Complied. Compliance affidavit was filed. On filing of the compliance affidavit, after the on perusal of the affidavit, the Honorable Court expressed this order, that the catena of judgments are there. I have been unable to locate a catena of judgments, which says that in all cases.
You can give your written notes that these are the judgments. Please look into it. That is that cannot be said to be a definite view which has been taken.
The whole difficulty is, the flanks are open in as much as the Vice Chancellor will be asked to appear in person.
If the Vice Chancellor is asked to appear in person, he should appear. If the court directs.
No, there's no harm in appearing.
The Vice Chancellor may appear. If the court imposes punishment, should receive that. If punishment is imposed, immediately you can come to the court. You have right to appeal. You can appeal.
All that is there. Where is the direction? My submission before your lordship is this, where is the direction which is being violated?
There was no such direction.
Because the direction is should. Should meaning from
your so-called reply. File your so-called reply.
We have filed a compliance affidavit.
When you again reply that we are not in contempt, we have complied with the order. Come do something. That court also has some jurisdiction. And for every order, we are not inclined to
this, your lordship if your lordship kindly peruses this judgment of the Supreme Court,
show before the court.
Grateful,
Contempt of the Supreme Court decision.
I'm very grateful, lordship may kindly bear with me, lordship may kindly bear with me, point. This judgment, 2006, volume 5, SCC, page 399, paragraph 12, page 411, the third, second paragraph from the top. In a proceeding for contempt, the High Court can decide whether any contempt of court has been committed, and if so, what should be the punishment and matters incidental thereto. In such a proceeding, it is not appropriate to adjudicate or decide any issue relating to the merits of the dispute between the parties. Any direction issued or decision made by the High Court on, any direction issued or decision made by the High Court on the merits of a dispute between the parties will not be in exercise of jurisdiction to punish for contempt, and therefore not appealable under Section 19 of the Contempt of Courts Act. The only exception is where such a direction or decision, Mallards. And if your lordship travels a little further, further, Mallards, this judgment also lays down the second point, Mallards. We will next consider as to whether an intra-court appeal under clause 15 of the letters patent was available against an interlocutory order dated so and so containing the directions on merits of the dispute. This is exactly my case, Mallards. Exactly my case. Now, Mallards, the next page. Clause 10 of the letters patent appeal of the Patna High Court, corresponding to clause 15 of the letters patent appeal of the Calcutta High Court, was considered by this court. Next page, Mallards. Central Mine Planning and Design Institute Limited versus Union of India. In that case, the award of an industrial tribunal directing the reinstatement and payment of partial back wages was challenged, and a writ petition before the High Court of Patna. The workman claimed interim relief under Section 17B of the Industrial Disputes Act 1947. The learned single judge directed the employer to pay full back wages to the workman during the pendency of the writ petition. That was challenged in a letters patent appeal. The division bench held that the letters patent appeal was not maintainable as the order directing payment under Section 17B of the ID Act was not a judgment. Reversing the said decision, this court held that an interlocutory order passed in a writ proceeding directing payment under Section 17B of the Industrial Disputes Act 1947 was a final determination affecting the vital and valuable rights and obligations of the parties, and therefore would fall under the category of intermediary or interlocutory judgment. Mallards. And para 15, interim orders, interlocutory orders passed, the last paragraph on that page, Mallards, passed and during the pendency of a case falls under any one of the following categories: orders which finally decide a question on the issue in controversy in the main case, orders which finally decide an issue which materially and directly affects the final decision of the main case, orders which finally decide a collateral issue or question which is not a subject matter of the main. Mallards. Your Lordship may articulate that, and Mallards, and a short observation that the Honorable Single Judge may decide that issue before proceeding further. Mallards, appellant is the Registrar, Biju Patnaik University of Technology.
Order dated 7/2/2023 by the single judge for in UNPC number 1383 or 2017 arising out of UNPC number 1368 or 2016 disposed of on 9/12/2016 and WP6C number 148 of 2005 disposed of on 1/12/2015. It transpired from the government's made in the present Intra-court appeal and other materials on report that respondent number 2 had filed the petition, that is WPC number Triple 143 of 2005, which to be disposed of by seeking regularization in service, which deal will be disposed of on 1/12/2015 with following observations and direction. Paragraph 20. Stop. It further that a contempt that the matter had gone up to the Supreme Court. This the single bench decision of this court dated single bench decision of this court dated 1/12/2015 has however not been interfered with. Stop. Later, a contempt application was filed by respondent number 2, which came to be disposed of by an order dated 9/12/2015, passed in CONTC number 1368 of 2017. Respondent number 2 filed another contempt case, that is CONTC number 1368 of 1383 of 2000.
It's respondent one.
Respondent 1. The contempt application, that is CONTC number 1383 of 2017, wherein the order in the challenge dated 7/2/2024 has been passed by the learned single judge, which reads as the
Page 85. 85.
relevant portion of which reads as under.
This quote is of the
Yes.
third line.
Paragraph P and 4. The aforesaid observation came to be made by the learned single judge in the contempt proceeding. In view of the stand of the appellant that the his regularization of service ought to have been done with effect from the date of his initial joining against the post, since he was appointed against a sanction post by way of valid selection process. Because it's the contempt proceeding is still pending. So the university has, however, chosen to prefer the present intra-court field on the ground that the said interim order is in the nature of granting such relief to the respondent, with respondent number 1, which was not granted to him by deciding his writ petition. This is your contention.
Months.
So he has submitted that the
In view of the observations made in the para 1,
that in
Para one,
of that
para 2,
of the
observations made in para 2.
next council appearing on behalf of the appellant has placed heavy reliance on the Supreme Court's decision in case of Midnapur People's Cooperative Bank Limited versus Sunilal Nanda and others, reported in 2006, volume 5, SEC 399, to contain that this intra-court appeal against an interim order passed in a contempt proceeding is maintainable. So, to bolster his contention, we have drawn our attention to paragraph 11 of the said decision, which reads as under. So, our attention has also been drawn to the observations made by the Supreme Court in paragraphs 12 and 13, which read as under. So, next. In our considered view, in our considered view, the observations, in our considered view, the stand is the university is taking in the present appeal could have taken. Your senior counsel has also submitted that where are you are relying on which decision to contain that the observations are incorrect.
I'm relying on Mallard's, the observations are incorrect, Mallard's. It was cited by the, it was
That that when a single judge in a contempt proceeding could not have gone beyond the scope of the direction issued in the writ proceeding. So he has further submitted that where is the Supreme Court decision? You are relying on which decision?
same, this judgment, Midnapur.
That this observation is observation
Mallards.
which has been made by the single judge is incorrect. This is what you want to say.
Mallards.
Where is that?
But this is the honorable single judge. My submission before your lordship is that the honorable single judge has dilated the issue. He has.
Sir, our point
Mallards.
is that some observation has been made
Mallards.
that this is the apex court has held in Ketna decision.
Mallards.
All right.
Mallards.
So do you say that the observations made by him, by the single judge,
Mallards.
are incorrect?
I say it
Legally.
Mallards. Legally, not. I could not find any Ketna decisions with no ratio laid down.
Then, just for the sake of litigation, you should not say that we will not follow. Then you are in serious trouble.
No. The difficulty is this, Mallards. The difficulty is this, that I'm relying on paragraph 22 of the single judge's judgment to say that the single judge has not given such a relief to the Mallards, to the petitioner. Single judge has not given such a relief to the petitioner. When the single judge, Mallards.
Someone is entitled to have something under the law he should get in whatever proceeding.
Mallards, that is true, Mallards. We will not stand in the way, Mallards.
Just there is no quarrel over the principle that even an interim order passed in a contempt proceeding in appropriate cases can be subject matter of challenge in an intra-court appeal under clause 10 of the Patna High Court. Letters patent of Patna High Court, and clause 10 of the letters patent of Patna High Court. So, however, on the fear of the considered opinion that it will be open for the university to take leave as may be available to it to satisfy the what during the contempt proceeding that there has not been any disobedience of any term of the orders passed by the learned single judge. So, in the present facts and circumstances of the case, we are not inclined to interfere at this stage in the present intra-court appeal. So, this appeal is accordingly dismissed with the aforesaid observation and
Can I only say one observation if your lordship permits me to make that? The honorable single judge will decide this issue and before proceeding further.
single judge cannot be done.
I bow down. I bow down.
Item 7.
It's a question of system. You should not have these observations.
By resolution dated 11/7/2016, the state of Orissa, under the scheme of
Which item is that?
under the scheme of Odisha Adarsh Vidyalaya Yojana, established Odisha Adarsh Vidyalaya, and advertisement we received
Odisha
for
Adarsh Vidyalaya. Odisha Adarsh Vidyalaya.
Adarsh Vidyalaya.
So this is PIL.
No pay, your lordships.
Then?
The petitioner is a trained graduate teacher under this school, Adarsh Vidyalaya, Odisha Adarsh Vidyalaya. The petitioner is a teacher in that school. In the initial advertisement, your lordships, the two categories of teaching staffs, your lordships. One is TGT and another is PGT. Trained graduate teacher and postgraduate teacher.
Mister, you are challenging the virus of the rules.
Lordship.
Where are those rules?
Rules, your lordships. One rule is, your lordship, is paid. Kindly have a glance to page
Please show
59.
us the rule which you are challenging.
By the annexure 8, your lordships.
Page.
Page 65, your lords. Page 65. And the relevant portion is at page 79.
So this is ultra virus.
Lordships.
What? Ultra virus which provision?
That is under page 79, your lordships. They have taken away the promotional avenue of the TGT ODI, your lordships. Initially in the rule 2019 rule.
Just a minute.
Lords.
Item 10 is also identical. Your lordship may kindly take up item 10.
Matter
Yeah.
deforested or?
Yes, similar matter, Marat have issued notice, and in fact.
You should notice, or we asked that exercise of power under certain
produce
articles of association that is to be
I
produced.
have, I have annexed in item number 10.
In item 10, when senior.
Your Lordship, when I come item 10, everything I have annexed. Today's item 10, same variance is under challenge.
So you are also challenging.
Yes, in item 10 of today's list. The article of association, I have already annexed in that. Wherein the Board of Governors have been given the power to frame rules and regulation in respect of the service condition of the teaching and non-teaching staff of Odisha Adarsh Vidyalaya.
No, the foremost question is whether that has a statutory force. It has been,
It is not under Article 3 zoning.
then how can you challenge? This should go before the learned single judge.
But that, this matter was before the honorable single judge referred the matter to the assigned bench. Item number 7.
Initially, I had filed that challenging the notification, your lordship.
But the matter in Iris where the statute had been challenged, then in that case, a division bench by your lordship.
No, but the
But where
assignment,
is the memorandum has been, suppose there is a violation of terms of the honorable.
Absolutely.
That has to go to the.
Initially, I had filed before the honorable single bench, your lordship, challenging that notification. That the notification itself is in violation with the previous. And not-
Clarify.
You have to clarify and just set it back again so that they can consider. If you are not saying.
8, 9 and 10.
no, 7 and 10.
7 and 10.
You say that these rules are framed beyond the scope of articles.
No, actually, in the year 2014, the government of India decided to open 6,000 model schools. According in the year 2014 and 15, your lordship, the memorandum, your lordship, I'm showing you.
It's a violation of Article
Good
14.
time,
your
good time.
lordship.
Odisha Adarsh Vidyalaya Sanghathan rules and regulations were framed. That is an article of rules and regulation. Under that, 24. The Board of Governors have been given the power to frame rules in respect of the to make regulations for determining the service condition of the secretary, other officers and other employees of the Sanghathan. And accordingly, a rule was made in 2015, then 2019, and the 19 rule was superseded on 6/1/24 by introduction of the 23 rules.
So where is the order by which the learned single judge referred the matter to division bench? Item 7.
7 to 20.
7 to.
In the item number 7, Marat.
Yes, that item number 7 is there.
Or Marat may kindly see 7 to 24.
7/2/2024.
Marat.
The
assignment, as your lordship have fixed, read petition on validity of statute of the single bench matters are related to assigned matters. This is what the assignment is. So it is not a statute actually. Statute as per the constitution.
the petitioner has in the present writ petition seeks quashing of Odisha Adarsh Vidyalaya bracketed method of recruitment and condition of service of training and non-teaching staff bracket close rules, 2023. Issued by notification number 187 dated 8/1/2024 by Odisha Adarsh Vidyalaya Sanghathan. So, on it is apparent from the said notification that the same has been issued in exercise of powers conferred by clause 7 of rule 9 of the articles of association bracketed rules and regulations of Odisha Adarsh Vidyalaya Sangathan. So stop. We are of definite view that the said rules cannot be said to be having statutory force. So stop. The rules have neither been framed in exercise of any power under the Constitution or any other law in force. So stop. When this writ petition was taken up on 7/2/2024 by a learned single judge, learned single judge passed the following order. 7/2/2024. Stop. In the court's opinion, since virus of an enactment or statutory rule is not under challenge in the present writ petition, the matter, as per the Constitution, as per the roster, as per the roster, should be listed before a learned single judge assigned with the roster. First off, list this matter accordingly before appropriate bench. कर दे हो गया उसमें will as per the roster in single judge we clarify that writ petitions on validity of statutes of single bench matters is to be taken up by a division bench, is to be heard by are to be heard by a division bench. Stop. List this matter accordingly before learned single judge as per the roster. Stop. Stop.
May I play for a date?
It will be listed.
Yes.
Will come to
7 and 10.
7 or 10. 10 में that order is not there.
No.
10 का अलग लिखोगे in the light of order passed in so and so, let it be placed before appropriate bench.
Item number 8.
May I please? Lordships may come to page 14 of the writ petition where the order has been passed that the learned district judge cannot hear the section 37 application for the reason that his father was the scribe of the award. So I filed the present application for transfer of that proceeding Because the award is of 2012 and we are not able to execute it within even for a period of 12 years. Page 14, your lordships. The order dated 12/12/2023. So the appellant and the Union of India, but since they have suffered the award, they are in no hurry to pursue the matter.
No, but you have filed this writ petition under which provision?
My lord, I understand that should be under the TRP. I apologize, my lord. That is the
You do
mistake.
You do that.
I'll subject to your lordship's permission if I'm allowed to correct it.
No, so you file a fresh petition. You should file a fresh petition.
All right.
When counsel for the petitioner seeks permission to withdraw this writ application with the liberty to file transfer petition under
24 of this.
appropriate under section 24 of the CPC.
I had in fact still out to the office, but
This application stands disposed of as withdrawn with the liberty as sought.
DPO.
Item 9.
This is a PIL matter, Miller.
PIL,
Yes, Miller.
are you sure?
The petition of the farmers and also landowner of the 4 villages. And they opposed by 3 and 6 to 7 intend to install grid co without to providing proper opposition to the petitioners. The petitioner, after acquired knowledge, filed their grievance, for which there is a meeting, by the annexure 4, page 40. That is minutes of meeting below. A minutes of meetings, they opposed by 3 and 6 to 8, they agreed to fulfill the grievance. Grievance of 1, they failed to provide, and for, so, kindly for a moment, annexure 4, page 40.
We
Grievance
have
2.
not been able to understand, sorry.
The present petition of the farmers and also the landowners of the 4 villages. They opposed by the 3 and 6 to 8. They intend to install grid co for installation of grid co mill without providing opportunity to the present petitioner. At the present petitioner, after acquired knowledge, they filed their grievance before the authority, before the collector. And thereafter, there is a meeting between the farmers and also opposed by the 3 and 6 to 8. That in the meeting, there is a minutes of meeting, annexure 4, page 40. In minutes of meeting, the opposed by the 3 and 6 to 8 agreed to provide passage for ingress and outgress of the cultivable equipments to their agriculture field.
So what are we?
But since
Are we there to execute the resolutions passed by at the level of block or panchayat?
my submission is that since the collector is seat over the matter and allowed the grid co to construct the boundary wall, obstruct the passage right and also water channel to their agricultural land, and the agricultural land for the agriculture and the petitioners, and they lose their agricultural land because, Miller, there is a water, there is no scope for the drainage of water in rainy season. But if the grid co construct the boundary wall more than 54.16 acre land, and the you kindly see, I have given the map.
Who has raised the boundary wall?
Grid co, opposed by 3 and 6 to 8.
Over your land?
Government land, Miller.
What is wrong?
Even with the government land, but so there is no way to ingress and outgress the cultivable equipments to the farmers.
Then you are claiming your right of easement under the PIL.
But passage right, more region passage right for the
Passage right, you can go before appropriate forum or court. Whose right?
Farmers right, Miller.
Which farmer?
The present petitioner depends the farmers, Miller.
How many?
More than 50, Miller.
So 50.
Yes, Miller.
So all of them can file appropriate application. Why should they come before this court? PIL. This is not PIL.
Kindly see, Miller, that they opposed by 3 to 6, they agreed to provide, and it's a grievance from 2 to 6. But now they are not, without fulfilling their grievance, they are carrying on construction. by obstructing the passage and also authorized channel for clearance of the from the agricultural land.
Where is
He-
that?
I've given, kindly see annexure page 36, page 30, annexure 2 will have given the map. And the
You are
one side
giving
there is
the
a,
map.
yes, I'm giving the map.
Now, where is the decision? Where did they assure you that?
Annexure 4, page 40. Annexure 4, page 40. Meeting was held between the official of OPDCL, Tahsildar.
So, 1, 2, 3, and 4 at annexure 4. They are your grievances.
Yes,
And what is the decision?
this minutes of discussion was referred to the collector. Page 41. But till now, collector has not taken a decision, but allowed the grid code to constitution boundary wall.
Did you approach the collector?
Already approached and page annexure 5, page 42.
Page?
Page 42, annexure 5. That way dispose.
Yes, please look into.
Yes, my lord. That annexure 5 is to be taken care of
3 and 5. 3 and 5.
by the collector.
3 and 5 million.
The
Annexure 5.
petitioners in the present writ application are the villagers of village Janbe Dhua.
Yes, my lord.
Janbe Dhua.
Yes. Ibrahim Singh, Gowda Sai, there are 4 villages.
In the district of
Jagat
Jagat Singhpur.
Jagat Singhpur.
Tirtol
Tahsil.
Tahsil.
Stop. The what is OPTSCL?
Odisha Power Transmission Corporation.
Odisha Power Transmission Corporation Limited is using a huge tract of land in and within the vicinity of the said village for developing electricity infrastructure to cater to the needs of coastal districts and to provide uninterrupted power supply to the coastal area and to aid various government development projects. The villagers raised certain objections over construction of project on the ground that the project shall cause obstruction in their day-to-day life, particularly the outflow of excess rainwater and flood water through the patch of land shall not be available, and some suitable drainage system should be arranged. First off, a meeting was held between the officials of OPTCL, Tahsildar of Tirtol and the villagers of the said village. Stop. It was said village on 10/3/2021. Stop. A decision was taken to forward the grievances of the villagers of this said village to the collector Jagat Singhpur. So, in the present writ petition in the nature of public interest litigation, the petitioners assert that the collector has so far not taken any decision despite the villagers having representing him way back, having represented him.
16th October 2020.
Absolutely. Representative. Full stop. Next. Learned counsel appearing on behalf of the petitioners has argued that the petitioners and villagers of the said village are poor farmers, and therefore the state and the OTPCL officials, state officials and OTPC officials have ignored to take note of their grievances and redress them. Stop. Next. Considering the facts and circumstances as pleaded in the writ application and submissions advanced on behalf of the petitioners, this application is disposed of with a direction to the collector Jagat Singhpur to address the grievances of the villagers as noted in the meeting of the officials held on 10/3/2021, minutes of which have been brought on record by way of Annexure 4 to the writ application. To stop. The district magistrate shall be under obligation to consider the same and take remedial measures within 3 months from the date of receipt or production of a copy of this one.
For orders, item 11.
In this case, your lordship has directed me yesterday to take instruction about the status of the appeal case, which was which ought to have been disposed of within a particular period, and thereafter we sought for extension. My lord, today is a holiday, public holiday, so I cannot contact the officers. Your lordship may give me 1 day time only.
Tomorrow?
Day after tomorrow. Tomorrow.
As requested on behalf of the estate, this
Thursday.
matter on.
First.
All right, Thursday.
Well, let a copy of the petition be served on me. He has not served a copy of the petition.
In this case, I am serving right now.
Item 12.
The petitioner is praying for revision of his pension. The retired class 4 employee, but he is He has rendered, my lord, more than 33 years of qualifying service, but to get 50%, 25 years of service are required. So at the time of calculation of pension,
This is a writ appeal.
a writ appeal, my lord. So when the honorable single judge during my absence at the time of adjudication of the writ petition, so it was dismissed, my lord. So the relevant documents received, my lord, under the RTI
So
Act.
you could have filed a review application.
Yes, my lord, because Annex 12 is not considered. I was absent at the time of.
Therefore,
Yes, my lord.
because you were absent, you could have sought a review. There is no illegality in the order. The order, see, when we say that the order is incorrect, we will have to say that despite all your submissions, your application was dismissed or whatever. You could seek a review. Learned counsel for the petitioner, after some argument, seeks permission to withdraw this writ appeal and seek review of the order under appeal in view of the submission that when the order dated 9/9/2022 was passed by the learned single judge, the learned counsel for the petitioner was not present and was absent because of circumstances not within his control. So stop. Next, this application, this appeal is accordingly disposed of as withdrawn with a liberty to the appellant to seek review of the order under appeal. Order of the learned single judge under appeal. Yes.
Item number 13.
My lords, and for the respondent, may I please, the applicant has approached this court, this writ appeal. It was dismissed for default in 2021. Restoration petition filed, not listed,
Is this
no defect removed.
No, is this a writ petition? CMAPL.
Yes, writ appeal was dismissed for default before lordships. It was filed, never listed, no defect removed. Your lordships granted thrice time to remove the defect. Last time your lordship had to pass a peremptory nature of order. Unless it is removed within that particular time, it will stand dismissed without reference to the bench. Thereafter,
Restoration, we are liberal.
your lordship liberal. What for the facts of the case? What for the facts of the case? The man is in the sick bed for last 3 years, not a fathom paid to him. His daughter died without any treatment. All these things were told to your lordships in division bench before the single judge 4 times. 4 times the insurance company, opposite party, the appellant before lordships, approached your lordship. Each time a subterfuge taking time. This is what I wanted to say, my lordship. This petition today, a certified copy was to be filed. 4 dates spread over 1 year. Your lordship gave indulgence, did not file. And lastly, to overreach the peremptory order, he has filed another miscase just to seeking 10 days time. The 10 days time has gone. In the meantime, 20 days passed thereafter. This is how the poor man is on deathbed. Let him get something for subsistence. The name is insurance company, LIC, not paying a fathom to the man who is dying.
May I please?
4 times decree has been granted by your lordships, single judge and division bench, confirming each judgment. With that pain, I am only disturbing. Your lordship, it's not a case for disturbance. Ordinarily, a restoration dismissed for default 2 years back, arranged not to be listed before lordship bench.
Let us hear him.
Lordship, I'm appearing on behalf of senior advocate Mr. J.K. Rath. Lordship, I seek for and pass over his on his legs, Lordship.
All right. We will take up the matter tomorrow. We are not inclined to allow this restoration application because of your conduct.
Lordship,
If what has been submitted by learned senior counsel is correct, the restoration application should be dismissed.
Lordship, it may be taken tomorrow.
Yes, we will take up the matter. The responsibility should surely go to your senior if we dismiss it.
But we are not. We will not do that. We will not allow injustice to happen.
Not so well intimate
Right.
the honorable court.
Yes. So tomorrow, and if we allow, then you will have to, we'll be imposing exemplary cost, not less than 10 lakhs. Your insurance company, you can afford that. You pay to the person, and you get the matter restored. They will hear you on merits. Not like this.
Not so well certainly intimate.
Yes.
the honorable
So we are liberal, but not that much. Yes.
Item note 14.
The review to file within time, if India may kindly contact.
Review, in fact, when you seek review of a writ order, is there any limitation? This court is to consider your whatever.
Let the concerned court decide that.
See, we are not superior courts. All right. Same High Court. We should not make such
I
observation.
pray during the pendence of this writ appeal,
That single Leonard single
not
judge would
be-
do needful. Yeah, proceed.
Item note 14.
Lordship, page 100 is the impugned order. I have given the similar copy, Lordship, that is the appointment under rehabilitation assistance scheme. Lordship can get page 100, the impugned order. Lordship has already decided the similar issue, that keeping in the issue decided in that Bindu Sagar.
Yes.
I have given that copy, ma'am.
Rehabilitation assistance.
Rehabilitation assistant.
Yes, same.
Item 15.
Item 15 also same, ma'am.
Same.
Item note 16.
In item 16, my lord, the impugned order. In the meantime, the original writ petition that has been also dismissed. Lordship, impugned order is at page 20.
Page?
Page 20, my lord, 20. Oh, sorry.
Order passed by the tribunal.
My lord, High Court, ma'am. This court, my honorable single judge, my lord, page 20, ma'am.
20.
My lord.
Yes.
That's who got it.
Yes, against that judgment you preferred
Nalini, that,
SLP.
no, Nalini Kumar,
Yes, Nalini
suddenly
Kumar
State of
suddenly.
Odisha,
Huh.
relying that order, this order has been passed.
Huh.
And against Nalini Kumar suddenly, we have also preferred writ appeal. That was writ appeal number 1526 of 2023.
Oh.
And that has been dismissed on the ground of limitation.
Oh.
So, my lord,
This is also delayed.
this is also delay.
So same fate.
So I cannot dispute that.
What is the delay?
The hereby delay is 180 days.
180 days. We have a filed limitation petition.
If I file a limitation, you lost my issue. My learned friend has appeared, I can solve the
We were normally allowing 90 days.
Yes, sometimes,
But beyond 90 days, we were reluctant.
sometimes before
I
that,
was party to that.
in some, but where the
So
substantial justice is to be seen, that's my endeavor. Only yesterday, one matter your lordship has allowed it to them, although I have paid cost of 5,000 in that
there was
case.
a merit in that.
So
We have seen
that,
the
yes,
merit.
that in some cases, if my lord has.
Unless there is a
Yes,
apparent-
yes,
there
apparent,
is an apparent merit
Yes.
in the matter,
Yes.
like the glaring question of law,
yes,
without delving into further factual adjudication of the
Yes.
issue.
This appeal is barred by limitation. By 180 days. Or 250 days.
250 days.
250
Right.
days. 250 days. IA number 4038. Sorry, where is that?
4037. Oh,
I number
Flag
four
C.
037. No, sorry,
Flag C.
4036.
38.
36. Limitation.
No, your
Oh.
brief may be wrong.
Yes,
Flag C.
maybe. Sorry,
C
madam.
flag.
In my brief, that is 4036. That is 4038.
38.
IA number 4038. Already, this application has been filed seeking condonation of delay. Stop. The only explanation which has been given for delayed filing of appeal is as under paragraphs 3 and 4 of limitation petition. Stop. The cause as shown by the appellants does not appear to be satisfactory, which prevented them from filing the appeal within time. So stop. We are not inclined to condone the delay, in the facts and circumstances disclosed in the limitation petition. So stop. Next. It is to be noted at this juncture that in the present appeal, an order dated 13/10/2022 passed by a learned single judge of this court in WPC OAC number 2641 of 2011 is under challenge, which has been disposed of in terms of an order dated, a judgment dated 5/8/2022 rendered in OPC bracketed OAC number 2642 of 2011. Well, bracketed Nalini Kumar Sarangi versus State of Odisha and others. Stop. The State of Odisha had preferred a writ appeal against the said order dated the said order passed in case of Nalini Kumar Sarangi, giving rise to WA number
1526 of 2023.
1526 of 2023, which too has been dismissed
On
by
3/11/2023, man.
dismissed by an order dated 3/11/2023 on the ground of delay.
Well,
stop. Next. Taking into account all the circumstances, this appeal, this appeal is dismissed as barred by limitation. Stop. Dismissed as barred by limitation. No. Taking into all the circumstances, IA number so and so is dismissed. IA number so and so seeking condonation of delay in filing the appeal is dismissed. So stop. Resultantly, the writ appeal also resultantly WA number so and so is also dismissed. Is also stands.
For instruction, my lord,
my lord, due to some functions are going on in the convocation ceremony is going on, little bit more time to take instruction in that affidavit, my lord. So, my lord, maybe taken up next week, my lord. We will in between.
So this writ appeal is barred by limitation.
Yes, my lord. We have filed a limitation petition, and respondent has also filed objection to that, my lord.
Now you will file reply to the objection.
No, my lord. Reply may be necessary, may not be necessary. We have sent it to the university, my lord. Next week,
Seems
may.
that you have a weak case.
Yes, my lord. My lord, last occasion, my lord, respond. My lord, senior
My lord, your lordship had directed, I am appearing for the respondent, my lord. Your lordship had directed to file our objection, which we have filed. And this is about regularization, my lord. 220 days delay.
About regularization.
This is about what?
About regularization. my lord.
Regulation matter, my lord.
Where is the
My
direction?
lord,
My lord, 22-24, my lord. Order dated 22-24, my lord.
So have you framed, you were required to formulate a scheme.
My lord,
Have you done that?
no, my lord, regarding that, my lord, senior will argue the case, my lord. My lord, I am seeking for the instruction from the university.
No, we will not. We will see your reply, your explanation. And we will decide whether limitation is to be condoned or not.
Yes, my lord. My lord, they have also filed an affidavit also, my lord. They have sought the copy on 29th, my lord. They have sent also that affidavit to the university.
So why are you challenging the order? You have already implemented the order. You have framed scheme. No.
No.
This is 97.
Oh, this is 96.
97. Another one.
Annexure 2 is something else.
Yes, ma'am. And I should.
There was simple direction to you to frame the scheme. You did not do that.
Yes, my lord. There is some issues, my lord. My honored senior will appraise that to the honorable court, my lord. But my lord, any date, my lord, next week or.
Yes.
Judgment is of 2020.
Yes, my lord. Yes,
my lord, 220
Admitting that, my
days. Delay not satisfactory. Explanation, my lord. that they are searching the files. That is their explanation. Because they have, after 2 contempt petitions were filed, my lord, they have filed the appeal, my lord. 220 days.
On the last occasion, my lord has heard the matter.
As requested on behalf of the appellant on the ground of non-availability of and senior counsel, Mr.
Dayananda Mahapatra, my lord. Dayananda Mahapatra.
Dayendra Mahapatra, list this matter on Monday.
Okay.
So stop. The court makes it clear that no further adjournment shall be granted, and the court shall consider the limitation petition on the next date based on the plea taken in the application seeking condonation of delay only.
My lord, there are another 6 matters, my lord. Similar matter, my lord, may be taken up next that day.
Let this be dismissed first, then
okay.
we'll.
Okay.
Item number 18.
Grateful, ma'am.
I beg to submit, my lord, that my lord fix the date 7th. Another analogous to way number 3121 by 2023, my lord. 7th. It may come on 7th because that is the
Why?
My lord, already same matters, 2 writ appeal, and 2 writ petition were there. Way number 3121 by 2020.
Then counsel for the appellant states
7th one.
that an analogous appeal,
Way number
that is WA
7th, my lord. 3121.
3121
And by
of
2023.
2023 has been directed to be listed on
7th.
7th.
Along with this one.
7/3/2023. So list this matter along with so on 7th.
Item 19.
Item 19 is same as item 14 and 15, my lord, rehabilitation assistance.
14.
Item 14 and 15, my lord, are just rehabilitation assistance.
Rehab.
Like this.
Item 20.
May I please, my lords? My lord, the petitioner, writ petitioner was awarded certain adverse remarks. He represented that representation was dismissed. Against that order, he approached my lords in the writ. My lord, may kindly turn to page 35 of my writ appeal, ma'am. Page 35 of my writ appeal, please. No, this is the writ petition, my lord. I have annexed. My lords have page 35. May I place the prayer the petitioner had? It is therefore most humbly prayed that this honorable court may graciously be pleased admit the writ application to issue rule to so cause as to why the prayer made hereunder be not allowed. Upon showing insufficient cause / no cause, make the said rule absolute and be pleased to quash the adverse remark communicated by due letter number such and such under annexure 2, that is at page 50, and the order of rejection of representation dated 11/9/23 under annexure 4, that is at page 54, declaring the same to be illegal, arbitrary and unconstitutional, and be further pleased to expunge the adverse remarks by directing the authorities to grant all consequential service and financial benefits. This was the prayer, ma'am. My lord, this on the honorable court, my lord, may I take my lord to annexure 2 at page 57.
Yes.
my lord, may I please paragraph 5? It's the last line. Having heard, my lords, got it?
Yes.
Having heard to learn and counsel appearing for both sides, and on a careful consideration of the submissions as well as the factual background of the present case, this court is of the considered view that since the issue is sub judice before this court, it is directed that the petitioner's case be considered by the DPC on merits without taking into consideration the adverse remarks. However, the final decision taken by the DPC shall be subject to any further order to be passed by this court in the present writ application. My lord, my humble submission is the consequential prayer has been granted by this honorable court. My lord, unless that adverse year is gone, consequentially cease to be. So, my lord, by this interim order,
You are challenging this order.
my lord, because my lord, by this the writ petition has been almost adjudicated.
No, that you will not, the final decision not be taken, but let the DPC
Yes, my lord.
consider.
My lord, I was expecting that question. Why we could not? What is our problem to consider his case for DPC, my lord? My lord, may I kindly have a look to that criteria of promotion rules. May I take my lord to that? It says 5 years, annual 5 years pass. Now, so we'll be violating the rules if we don't consider these CRs and consider his case.
Now, consider another situation. When you hold the DPC,
My lord.
you don't consider his case, and later this court expunges the adverse remark.
Yes.
Then
My lord, he gets?
no, because you have already filled up the seats. DPC is for promotion. Promotional posts are filled up.
My lord.
So that the third party rights are not created, this order was passed. So you consider you don't grant him promotion. If finally he succeeds, he'll be getting promotion. If he does not, he will not get promotion. The other person will get promotion. But instead of filing the appeal,
May I show, my lord, that criteria of promotion?
we can understand.
No.
And therefore, you don't take a fine, don't promote him. But let his case be considered in the DPC on merits. Petition has been disposed of.
No. Thereafter, next order, Annex 3. Thereafter, that correction. Actually, my lords intended to pass that interim order only. Wrongly, writ petition was next page. That has been corrected. May I humbly pray, my lord, with that observation, my lord just now said, with that observation, the writ will be dismissed. Obliged.
By filing petition. Giving rise to
May I interrupt? I'm sorry, I must bring it to my lord's notice. There is a delay of 75 days. Obliged.
This has been fixed for hearing to 8th of April, my lord, already.
So we are just disposing of the writ appeal. We are
Yes,
condoning
ma'am.
the delay. We are condoning the delay. We are disposing of the writ petition without any. We are not interfering with the order.
All right, ma'am.
Do you have any problem?
No, my lord.
I number 7. The delay of 80 days in filing the petition. The writ appeal stands alone. The facts and circumstances. So, with WA. The respondent number one. What is for? Has approached this court by filing WPC number P272 of P lead by adverse remarks entered into his service. Stop. During the pendency of the writ petition, meeting of the departmental proceeding meeting was going to be held for promotion to higher post. So, the current single judge of this court, considering the prayer of the in the departmental promotion committee meeting for promotion, comma, passed the following order on 9/11/2023. It is 26. Paragraph 6 of which reads as under paragraph 5 or paragraph 6?
5.
5 of which reads as paragraph 6 is not there.
Paragraph 5.
6 is not there.
Not there.
Oh. In paragraph 7 of the said order, paragraph 7 of the said order mentions that the writ application is so, the order dated 19/11/2020 will be modified subsequently by an order dated 19/12/23 past 5 runs single judge. Paragraphs 3 and 4 of which read as apparently the petition is pending. So, the court by single judge by an order of 19/11/2023 has required the state required the appellants to for consideration of the respondent's case for promotion by the EPC without taking into account his adverse remarks. Next. Let counsel appearing on behalf of the state/appellants, state of Odisha/appellants has argued that consideration of the case of the respondent overlooking adverse remarks would be contrary to the rules.
Rule 3C of
Rule 3C of
Odisha Civil Service within bracket criteria for promotion, bracket ends, rules 92.
So, next. We are not inclined to interfere with the impugned interim order passed by
the learned single judge for the reason that the order was apparently passed to pass so that no third party right could be created. In the meanwhile. It has been clearly mentioned in the order under appeal that the decision of the departmental motion committee shall be subject to the final outcome of the writ petition. So, in our considered view, in the facts and circumstances, the impugned order does not require any interference. This writ appeal stands.
My lords, we're observing that yes, we can keep it, we can take the consideration and keep it in sealed cover.
Do whatever you want. See, we are not to advise you. You consider, you keep it in sealed cover, whatever you do, you can tell Honorable Single Judge, let's see, this is what we have done. Now we are under the order of the court. Things happen.
I was only saying that because lest it may be construed as contemptuous, because tomorrow, if we might not say that yes, we have considered, we don't find you suitable, it will be tested before the Honorable Single Judge that it is contemptuous. That is our predicament, nothing else, ma'am.
Anticipating release the wrong.
Obliged.
Item number 21.
May please your losses. This is a matter relating to the industrial policy resolutions, IPR benefit under the Orissa Sales Tax Act matters. Whether the petition is entitled to get the benefit under the IPR on the tax holiday matters and 96 IPR matters, government is all withdraw matters. So IPR 96 subsequently government is withdraw matter. So my losses friends is presenting and losses passed according to dispose of the case matter.
96 has not been withdrawn. 89 were withdrawn.
89 withdraw matter.
It is under 96.
96
IPR.
losses.
No, 96 IPR lost its utility after 5 years.
Losses.
Of that period was over.
Losses.
Your Lordship has already decided the issue that case is also tagged. Your Lordship might have remembered also review petition has been dismissed. That matter has been tagged also here, 10,043/1999. Your Lordship, here the withdrawal has been challenged and it is, this writ petition is the consequential of withdrawal, Your Lordship. The withdrawal of notification dated, Your Lordship,
96 and 2001. All IPRs were withdrawn because of VAT.
44, Your Lordship, 30th July 99 notification has been challenged in this writ petition, and Your Lordship has confirmed that withdrawal in view of 2 judgments of this Honorable Court as well as Honorable Supreme Court. So this case is covered by that judgment, Your Lordship.
That is the story. Losses on that observation, losses disposals.
Because this writ petition, this challenge is the consequential. Same challenge. So far as the prayer B, C, D, all are the same challenge. So for the entire period, he wants to avail the benefit, but that benefit has been withdrawn.
That the controversy involved in the proceeding stands settled by
this Honorable Court. Your Lordship,
this court's decision in case of
same petition.
Mr. Sri Jagannath
Sorry.
Versus State of Odisha. reported in 2005. 141, 26, bracketed ORI. Above subsequently by the Supreme Court. In case of reported in 2005 volume 10 SCC 423. Are we correct? Petition filed by the same petitioner, that is OPC number 10043 of 1999, has been disposed of in terms of the aforesaid judgments by an order dated 6/11/2023, which related to withdrawal of the Finance Department notification and withdrawal of exemption benefits extended in consonance with IPR 1989 by virtue of the Finance Department notification dated 30/7/1999 effective from 1/8/1999. So this matter relates to
This petition.
the present matter relates to the industrial policy. What is R for?
Resolution, Indian policy resolution, IPR.
1996, which has been withdrawn. Which has been withdrawn. Withdrawn. So stop. For the same reasoning, comma, same reasoning available in case of last bankers bracketed supra. This application stands disposed of in similar terms.
And also review petition, in that case has been dismissed.
We need that.
Your Lordship, great.
May my lord, if my lord will permit me, may I say, item 20 I will withdraw to move the announcing. Obligation.
Item 22.
That's item 22. In this case, bleedings is over. May I request your day after tomorrow?
22, do you know the year of the case?
Let's, yesterday night, it's came to me, that's why I came day after tomorrow. I will complete.
Listed on behalf of
Let's.
Item 23.
Lordship, 2 weeks time may be allowed as a learned senior is suffering from cardiac issue. In the meanwhile, government was to supply some instructions.
Lordship said also directed me to obtain instruction because your own
The ground which you have taken for adjournment, we cannot refuse. But this case is of 1999.
Yes, Your Lordship. That's it.
Suffered cardiac problem
Yes.
and is not coming to court. So as requested, that this matter of lease. So if the matter is pending since 1999, we make it clear that no further adjournment shall be done. This matter is pending since 1981.
No, Your Lordship, in the last date, kindly have a glance at on the last order. The court has asked the government to supply some sort of instructions, which is only 1 month below. Oh, bless.
item number 24.
Wait, please. What that?
Yes.
White sale deed dated 29/9. That we have purchased the land and that was acquired by the government. Land acquisition. Land acquisition purchase was in the year 1983 and acquisition notification was given in 84, 1810-84. Then the acquisition was challenged on the ground that the lands acquired are not for the benefit of the people, but for the commercial purpose because they have been acquired by the government for the purpose of allotting it to the development authority to raise construction. Whatever be, a writ application was filed, OJC 2731/88 by similar, for challenging the similar notification. That was disposed of. While disposing of the writ petition, they have upheld the acquisition, but this honorable court said, since the land has been acquired, a similar land should be given by the nearby place because vast lands are there to be given. So that part was over. Then I have filed the present writ petition, again on the same ground, saying that let me also be given a similar land elsewhere. They have filed a counter saying,
Yes.
they have filed a counter stating that the land that was purchased by me was from my vendor. My vendor's title is defective and therefore they will not give the company. And in the counter they have said they are proposing to challenge those orders and therefore they have not given it. This counter has been filed by opposite party number 2, Development Authority. And in the meantime, when the matter was being taken up, after several adjournments, a statement was there on record. A statement was made by the Development Authority saying that they do not require the land anymore. And they wanted to give it back to the government. Now, government has been taking time by saying that we will demarcate and find out who is the owner and what is this, all these things. And now they are neither paying the compensation nor returning my land. If they don't require it, let them return my land to me. Or if they pay the compensation, well and good. Because land acquisition proceedings, I can't assail them and on whatever ground, since in earlier writ petition, it was already decided that acquisition was valid, but some other land was given. I also prayed in the writ petition to give me some other piece of land somewhere else.
Neither they are doing that, nor they are giving the compensation, nor returning my land. This is my state of affair, and it is for the state to respond, my lord.
Yes, madam. My lord, after the land was handed over to the development authority and they filed affidavit that they don't want this land to be taken up anymore. And then the honorable court has directed that you return the land to the revenue department, and revenue department will take care of the land, whether it will be returned or any compensation is to get. Meanwhile, we have filed an affidavit that process is, I have to, with due respect, I have to take instruction whether that returning process has the development authority lawyer is also there. Returning process is already completed or not, that I have to take insurance. And the other part is that we have filed a counter that this land is a Patita land, a government land. The government has also challenged the title of the petitioner or petitioner's vendor's vendor, and that is why they are not entitled for any relief in respect of the land in question. That is also taken. So the first question is as per the direction of the honorable court, we have to make the survey that after the land is returned to the government. So your lordship can give me 3 weeks time. I will take that whether the land has been returned by the development authority and whether any survey has been made. This is in the Varanasi project, and for that purpose I pray.
Order.
Yes, that order is there
Thereafter, another order was also.
for compliance of that order.
6380.
Yes, several adjournments.
So same.
That
It stood there. What you contended at that time.
regarding
same
that return and survey, that particular instruction I am lacking today. I have for the new, this file is new to me. I will take instruction, and I assure your lordship that on the next date I will come forward with a.
So 6 years.
And the development authority lawyer is also there, because there has to be a documentation regarding.
His senior is not there.
His senior, because he is the main person who knows everything. We are all new to this.
By this order,
Yes, that is there, your lordship.
this order has been complied with her.
That survey matter, what your lordship has directed, we have to make a survey.
Whether 5/2/2018 order has been complied with.
In compliance to that order, we have to give the affidavit. That affidavit has not been. That affidavit has not been filed.
One word, whether
Yes.
the order dated 5/2/2018 has been complied with.
In pursuant to that order, we have not filed. We have not filed. We have not filed the affidavit.
Please say yes or no.
No, we have not filed, madam. That is what I am saying.
Who was required to comply with the order?
The land action section.
Please read order dated 5/2/2018.
That is.
The photocopy of the sale deed was handed over in compliance of this order.
Yes, sir.
You had handed over.
Yes, yes.
Huh?
I have handed over.
To whom?
State council.
15-1.
5/2/2018. That order is not uploaded.
No. It is very old. At that time, it was.
At that time, there was no uploading. That order has not.
A lengthy order was passed on 15/1/18 also. Very lengthy. Describing all requirements to be done.
No, what are you doing?
My lord,
5
that's,
years you are just in the process of verification.
that physical verification that has to be completed within, but there is no instruction whether it is, your lordship may grant me 2 weeks time. I will.
Waiting for some new technology to come. This is too much. The order was passed in 2018 and we are in 2024.
In January 2018,
Yes.
after making of statements, in view of the fact that some part of the acquired land has been occupied by the
Unauthorized.
unauthorized persons. In the meantime, the State Housing and Urban Development Department is to carry out the physical verification of the acquired land and survey of the same through collector and Tahsildar Cutter in order to find out the extent of unauthorized occupation over the said land before a decision is taken to return the land to the original landowner. Otherwise, the entire exercise may be rendered nugatory. Therefore,
My lord, as a
this-
last chance.
therefore,
I pray that
please.
as a last chance, yes.
Therefore, the Secretary Housing and Urban Development Department, opposite party number 1, is directed to take necessary steps for physical verification and survey of the acquired land in question, especially with regard to unauthorized illegal occupation of the same in the meantime. That was January 2018.
Yes.
Then 5/2/2018. Some time was
We are
Ask
initiating
for.
contempt proceeding against it.
My lord, the 1 week time may be granted, 1 week last
No.
chance. Your lordship may kindly consider 1 week last chance. If your lordship will next Tuesday,
Whatever it is.
my lord, last chance 1 week. If we cannot comply this, your lordship can issue any order. For the first time, the file is coming to us. So your lordship may 1 week. Next Tuesday, it may be posted. Next
Yes.
Tuesday.
Sorry. This writ petition was filed in 2001. So from 17 years thereafter, being more than 16 years thereafter, when during the course of hearing of the present writ application, an order was passed on 15/1. Briefly narrated, it is the petitioner's case that his land was acquired by the state government for being handed over to the Cuttack Development Authority. No problem. The Cuttack Development Authority subsequently was of the view that the said land was not required for them. And accordingly, the land was to be returned to the Land and Revenue Department, Government of Orissa. No problem. In between, the process of acquisition of land and the decision of the Cuttack Development Authority not to have the land for its purpose, the petitioner's land appears to have been unauthorizedly encroached upon. No problem. Disputes have also been raised as regards the title of the petitioner's vendor by the Cuttack Development Authority and State of Orissa both. So, be that as it may, when this writ petition was taken up for hearing on 15/1/2018, following order was passed. Subsequently, this court passed following order on 5/2/2018. So, later, yet another order was passed on 6/3/2018, which reads as under. So, more than 5 years later.
May I be permitted to submit one thing, my lord? I found a document from my record. After this order, a joint inquiry was conducted, and the joint inquiry report is there. All the CDA officers, Tahsildar and land acquisition officer, and they found that the exact position of the suit land could not be identified out of the area which has been used by CDA for wilderness so and so. And to that effect, exact location of the plot, the cell deed with sketch map of the suit land is required, without which it is not possible to make a clear identification of the land. Accordingly, in order to go ahead with his
When was it done?
this is done in 2018.
When date?
1st February 2018.
Therefore, the order was passed on 5th of February.
Yes, my lord.
Because of this,
Yes.
5th of February order was passed.
That
You required the sale deed to be handed over. The sale deed has been handed over.
cell deed, yes.
More than 5 years thereafter, when the matter was taken up, time was adjournment was obtained by London Council 588 representing the state. So, during more than 2 decades of pendency of the petition, the original petitioner died. And your application has been allowed, are you remember?
Yeah, number that was there in the last date. I have mentioned that it was not allowed. So that was directly.
Accordingly, an application has been filed by IA number 42 of
2020.
a substitution application. That is IA number 42, which is not there on the cost. Is it there?
Black B.
Plus B, yes. IA number 42 of 2020 has been filed for substitution of legal heirs in place of the original petitioner. Where is that? Yes, it is there. Next. IA number 42 of 2020. The original petitioner died on 39/2020. This application has for substitution has been filed on, came to be filed on 10/12/2020. The description of the heirs and the legal representatives of the original petitioner finds place in paragraph in the first title of IA number 42 of 2020. So this application is allowed. So, left. Press first title.
He has already filed.
First title you have filed.
Consolidated cost title is already there.
I have filed it.
The consolidated first title has been filed. So, the applicants who are here as legal representatives of the original applicant or original petitioner and substituted in this case. So, next, keeping in mind the court is of the view that defiance by the opposite party of the court's order passed way back in 2000 in in February 2018 constitutes a gross contempt of this court. So, the opposite party has shown least respect for this court's order. So, we accordingly consider it fit to initiate suo motu contempt proceeding against the state officials and the officials of the CDA who are the opposite parties here. So, for the said purpose, we direct the Chief Secretary Orissa, Chief Secretary Orissa, and who is the
Housing,
who is the head of CDA?
CDA head or chairman.
Chairman. As per my lord, we have already filed an affidavit regarding.
Just a minute, please wait.
Sorry.
CDA.
May I frame?
Just a minute. Let us complete your CDA. Furnish the list of such persons who were obliged to carry out this court's order passed in 2018 till date. So, we make it clear that the Chief Secretary and
Chairman.
and the chairman of the CDA shall be under obligation to furnish names of all such persons holding the positions in the state government and the CDA responsible for non-compliance of the order right from the date when the order was passed in 2018 till today. So, this case on 2 weeks when the court shall consider initiation of contempt proceeding against the responsible persons. Yes.
May I brief? Lords may observe that in the meanwhile, the order.
You can do that. You can do that. May dilute. We don't know. That may dilute the situation.
Yes.
Only this much we can observe.
That.
Otherwise, it will aggravate.
Yes, I, your Lordship.
Yes.
may observe that.
Item 3, same.
Lordship may observe that if in the meanwhile.
No, we will not observe.
Subject to compliance of the order.
No, this is not subject to. We will next time We will see if we find, we will initiate.
Item 25. Item number 25.
Actually. वो कॉन्फ्रेंशियल कर सकता है? Behalf of the petitioner, discuss this matter tomorrow.
Item number 26.
Minutes I'm appearing on behalf of the petitioner, whereas the petitioner seeks to withdraw the matter with liberty to file afresh, if any cause of action survives.
Then counsel for the petitioner seeks permission to withdraw this application with a liberty to approach appropriate forum if the cause of action still survives.
Well, appeal is pending. Both the parties are participating in the appeal in this case, my lord.
Therefore,
That's mentioned, so because they have admitted in their rejoinder.
the petition stands disposed of with the liberty as sought. So also make it clear that if any proceeding is pending before any
Appellate
authority concerning the matter in relation to the same subject matter, the same may continue in accordance with law. So we have not made any observation on the merits of the case.
Much obliged.
Item 27.
May it please your lordship. My lord, as the noting says against this item, a counter affidavit has been filed on behalf of opposite party number 1 and 3. I humbly pray your lordship that they may be directed to serve a copy on me, that counter affidavit, and I may be permitted to file the rejoinder affidavit, and for that reason, your lordship may take up the matter after 4 weeks.
So for 9 years, more than 8 years, we are just in the process of filing counter affidavit not served.
I am serving.
That
Yes, my lord, now I am sorry.
a counter affidavit on behalf of, a copy of the counter affidavit on behalf of the opposite parties has been served upon learned counsel for the petitioner today in court. So he seeks how much time?
After 4 weeks, ma'am. And the petitioner is a handicapped person, my lord. So it is becoming difficult for his path. So that's why I am taking it more time. So that he will be able to
counsel
come.
for the petitioner seeks 4 weeks adjournment to consider the said counter affidavit and file a rejoinder if so required. So place this case on 4 weeks.
Item 28.
May it please your lordship.
Just a minute.
My lord, I have gone through the lordship's judgment dated 21st February 2024.
What did I do?
My lord, everywhere is violated, my lord, throughout the state in presence of my lord and seniors. Even if the decades before,
present petitioner.
What happened? What order was passed?
This is the nice judgment. Not only myself, entire bar was intending like such judgments.
What is there? This is about
Judge, there are some provisions, my lord, but authorities concerned empower.
That order, encroachment.
Yes, my lord.
Encroachment matter.
My lord.
All right, then you follow that order.
I'm ready to follow, but earlier honorable court directed to carry out the to dispose the representation, present petitioner before.
Now you can go there with this order.
Against whom allegation he has not filed any reply to the petition, my lord. Opposite part number 5, that Tahsildar, your lordship, just for a moment, your lordship kindly see page 5.
But now since the order is there,
that is pending, my lord. They are not carrying.
This is not pending. Now the order has been passed.
My order has, but initially I have filed this writ application in action of the revenue authorities. That is opposite party number 5, Tahsildar Tangi, my lord.
Which item?
My item 28, my lord. Item 28, my lord. Your lordship kindly see page 5, my lord.
Is this a PIL?
But honorable.
Yes, my lord. And your lordship has in the judgment has said that if the authority do not comply the same, it shall amount to contempt.
So therefore, you can approach the authority with this order.
Yes.
Which we have passed.
But I have filed the application.
You had filed that long back when there was no judgment. Now there is a judgment. And that judgment contains directions that what they are required to do. So they are under obligation, statutory obligation, and also
my humble prayer, accordingly, your lordship may pass order.
All right. The present public interest litigation relates to a removal of encroachment from public land.
Public land, that is Kisam in Gochar, my lord.
Public land in the nature of Gochar. Next, this court has recently issued certain directions in case of so and so, where they on
Tirnath Panda versus Commission.
In case of so and so, to the authorities to deal with a situation when they receive information regarding illegal encroachment of public lands. Stop. This writ application stands disposed of in terms of the said order. First off, the petitioner shall be at liberty to approach the appropriate authority along with a copy of the order dated so and so, past and so. Yes.
Obliged.
My lord, as per my lord direction, the president of the Odisha Medical Research Council is present today.
My lord, may kindly see my lord's prior order. Date
Please sit.
27th of February.
Please sit. Please.
My lord's order wherein relating to those fake doctors. For convenience also, we have given a short note for the court, which is on top of the record. That's what it says. Indicating about the previous developments and what the court.
Yes, please, come. What is your name?
Dr. Vijay Kumar Mohan.
You are chairman.
Odisha Council of Medical Legislation.
Medical Association,
Registration.
Odisha Council of Medical Registration.
medical registration. So what do you suggest? You must have seen the orders and
Sir.
you must be knowing the reason why we have called you.
Sir. Sir, my humble submission is that till date we have taken care of the allopathic practitioners who are not registered and not registered. We have a list of 31,355 allopathic fraternity medical officers. And after validation, we are going to make it open in the website by March 15th. But the crux of the thing is that when you take about this quart maintenance, there are other fraternity also working. One is homeopathy, one is Ayurvedic, and one is dental council.
No, they are entitled also.
Yes, sir. No, they
are prescribing allopathic medicines.
No, they are allowed to prescribe allopathic medicine. Dental doctors, they are allowed. This homeopathic and Ayurvedic also, they are registered, they are not registered. In name of Siddha, in name of this Tansi Chikisala, anything. Many groups are there who are not affiliated to any science.
First of all, one by one, let us come to the allopathic doctors.
Sir.
So what do you suggest about them?
So allopathic doctor, we have already, as per the Honorable Post decision, we have taken care of, there are three things we do. Number one is registration of basic doctors. Number two, additional qualification. Number three, renewal. Number four, any medical negligence which is brought to the notice of the...
No, our concern is different.
Sir.
Suppose if you do everything, but in a room or in a building,
Sir.
or even if you put that on the website, so what is the percentage of the people who use the website?
Yes, sir. That's it.
So you will have to reach out to the people,
Sir.
to tell them, or you must have some mechanism so that they may identify as to who is genuine and who is not. So from this perspective, you will have to chalk out your plans.
Sure.
This is what we suggest. Suppose you in the room, you do register doctors. Then in the room, you have 5 of such doctors who are eligible to practice. Then in the room, you have everything in that building. And finally, you decide that now the database we have prepared. Now, the maximum what you are trying to do is that to put everything on the website so that it is available to the public.
Sir.
Oh, is that available to the public?
So next thing we have discussion with NMC, we have planned to transmit all this information to district level, where the CDMO's office, there is a grievance cell and it will be there. It is very difficult to just publish everything as a CSC and local PSC level. At the first phase, we will take steps.
Why is it difficult?
So PSC only voluminous things will not be, manual things will be there. It is very, there are net issues in many
No,
places.
not physical things.
Physical things.
Physical things. Can you think of issuing some identity for a doctor, for an allopathic doctor, which he can put at some significant place? Every doctor, right from the chief of the medical service in the estate till the lowest rank, he is medical officer or assistant medical officer. From him to him, or for any doctor, if you prescribe something, even pharmacy, if you can prescribe that you should put this thing, so that anyone, even a illiterate tribal, may identify if he or she is made known that this is how you can distinguish.
So,
all right. even in that case, there can be misuse. Misuse in the sense that there can be instances of impersonation that can be dealt with. That can be dealt with, but can we have such systems? Therefore, we wanted you to come out with think over. We are not in hurry.
Sure.
Think over, come out with different proposal, definite proposal. Talk to your office bearers. Talk to the chief of the medical staff of the estate and other doctors. Please come out with some definite proposal how to deal with this.
Sure.
And that was the reason why we wanted you to be here.
Sure.
All right, so that we may communicate to you what is going in our mind.
Sure.
Only from my lord that some of the pharmacists also, they are also prescribing medicines or giving medicines.
Sure.
So they are not authorized to do that. Therefore, we will be dealing with first the this thing, the allopathic medicine, and then you suggest about others also. All right. Come out with some definite proposal as early as it is possible.
Sir. I will be discussing with NMC also and give some suggestions.
And you know it better, rather better than us, how to meet the situation, how to handle the situation. And for that, if you require any order from this court, we will be doing that. So it is not an adversarial kind of thing. All of us are for the public.
Any instruction will be better so that I will communicate with NMC.
Communicate
With the NMC, National Medical Council.
National Medical.
You are for both DMT as well as
National Medical Commission.
Even the health secretary probably has to be involved.
Yes, yes.
State-
Also
state health secretary.
Department of Health and Family Welfare Secretary will also in tandem with the President, they will sort it out. We'll also.
And if my lord would see the other issue which was taken up by the court, order number 10 dated 22/6/2023. Paragraphs 6 and 7. Wherein in para 7, two questions were formulated. The important in this context may be 7 Roman capital 2.
Oh, that my learned friend is given last time in
Whether any
his summary.
surveillance. Surveillance mechanism to identify the fake doctors is operating in the state of Orissa. If not, whether the state opposite parties are contemplating to introduce surveillance. This is something which they have to think about. I think nothing has been done in this.
That means, in fact, along with the president of the society, the secretary, they will talk out notes. Also, my director will do it together.
And what role the petitioner will play?
Here at your lordship, when this legal services, it was at the instance I was doing it as an amicus.
So legal service authority can reach to the people, the grassroots level.
Yes.
The paralegal volunteers, they can educate the people at the level of Gram Panchayat or even villages.
Certainly.
So their services may also be utilized for this purpose.
Dr. Vijay Kumar Mahapat.
Dr. Vijay Kumar Mahapat. V or B?
B, sir.
B.
Bijay.
Pursuant to this court's order, Dr. Vijay Kumar Mahapatra, the chairman,
President.
Chairman,
President,
Council
Odisha
for-
Council of Medical
He's not the.
Council of or for? Odisha Council of
Medical Registration.
Medical Registration is present. Stop. He has assured this court that he shall he shall come up with definite suggestions to meet the challenge of meet the menace of the fake allopathic doctors in the state after consulting the National Medical Commission. National Medical Commission. National Medical Commission and the Health Department Secretary.
Yeah.
Secretary, Principal Secretary or
Commissioner come secretary.
Commissioner come. Commissioner come Secretary.
Health and Family Welfare Department. Health and Family Welfare Department.
Health and Family Welfare Department, Government of Odisha. Stop. We expect that while putting up his suggestions to this court, he may also consider the mode of identification of genuine doctors in a manner that even an illiterate person living in remote areas can identify them and can distinguish between a genuine and fake allopathic doctor. Full stop. He has informed this court that a database of the doctors registered by the Odisha Council for Medical Registration is being prepared, and that shall be placed on the website. Stop. Website of the council. Stop. the state government, once the database is ready, once the database is prepared by the council, it may be beneficial for the state also to utilize that for making it available in public domain. Full stop. Next. Mr. Mistral and senior counsel appearing for the petitioner has drawn our attention to the court's order dated 22/6/2023, wherein the state opposite parties were required, whereby the state opposite parties were required to file an affidavit as to whether any surveillance mechanism to identify the fake doctors is operating in Odisha, and if not, whether they contemplate to introduce such surveillance system. Have you filed any affidavit?
No, no, sir. For subsequent to a lawsuit, I would file earlier, but subsequent to lawsuits ordered no affidavit.
Very difficult. Very difficult.
No.
This order was passed.
No, that pursuant to that affidavit was filed, but that affidavit, as per my learned senior notes, was not covering all the notes, aspects mentioned notes. I had filed that affidavit. You will also look at the order dated 13/2. On 13th of February, I served a copy of that affidavit on my learned friend, pursuant to lawsuit direction, but it was pointed out that it has not covered all the notes.
Oh, but the surveillance aspect has not been considered.
Yes, surveillance and two more
Surveillance has
things.
not been addressed at all. They have somehow missed it.
No problem.
And that is actually the core issue of
an affidavit has been filed by the estate on behalf of the estate subsequent to passing of the order, passing of the said order dated.
that is a flag F. Flag F is what the list indicates. Dated 28/7/2023.
Order dated 2023. First off, it is unfortunate that the said affidavit does not address at all the issue as regards surveillance mechanism taken note of in the said order. Stop. we direct the Commissioner cum Health Secretary, Government of Odisha, to file an additional affidavit specifically addressing the issue of surveillance mechanism to identify fake doctors as noted in this court's order dated 22/6/2023. Stop. The additional affidavit must be filed within 2 weeks from today. Stop. List this case on 3 weeks. Stop. The court expects that in the meanwhile, Mr. Vijay Kumar Mohata Mahapatra, Chairman OCMR, what do you call it? SCMR? President, Chairman, President Odisha Council for Medical Registration shall submit to this court his suggestions in view of the observations made herein above. So stop. That's all. Anything? We record our appreciation for the assistance extended by Mr. Dr. Vijay Kumar Mohapatra to this court, and also for his assurance to the court that he'll help us reaching definite conclusion in the conclusion in relation to conclusion dealing with the menace of the fake doctors in the state of Odisha. Yes. So that assurance we have recorded. Is that there?
I'll submit. I'll submit, sir. I will submit, sir, in consultation with the agency and government.
It will be good if you come on the next day, but we are not mentioning that in our order.
Okay.
Item number 30.
May it please your lordship. But I'm challenging the order of the learned single judge, whereby the learned single judge has directed the appellants to grant promotion to the respondent pending vigilance proceedings. The order is at Annexure 1, page 13, your lordship may. Page 1-3, Annexure 1. Your lordship has page 13.
Yes.
May I point your lordships out that this was order number 1. Therefore, this writ petition was allowed on the very first day of hearing without issuing notice to the appellants, without serving a copy to the appellants. Therefore, violation of natural justice. Your lordship, it's a very short order. May I read paragraph 3?
Issue notice.
My lord, this is a matter for final hearing, your lordship. Your lordship, the respondent is appearing.
I'm appealing for respondent number 1.
No, but this order was passed on the very first day.
Your Lordship, that's why, Your Lordship, I am coming to. Your Lordship may see the ground of challenge. That what now he is submitting, that is the ground of challenge. And similar case,
No,
my lord.
Similar, forget similar.
Yes, Lordship.
The
Division
question
bench has passed this order. Lordship, have a glass to this.
Mr.
My lord.
The only question is,
My lord.
every day we preach principles of natural justice.
My lord. That's why
So
this order
whether
has been passed.
Therefore,
Division bench has passed this order, Your Lordship.
what?
Yes, Lordship.
What is the position now with regard to this vigilance case?
Well, the vigilance case
Charge
is still
sheet has
pending.
not been submitted as yet, Your Lordship.
Vigilance case is still pending, but in respect of the disciplinary proceedings, he has already been found guilty and punished.
And that has been stayed by this honorable.
That has not been stayed by this.
Yes, that has been stayed. That I am the submitting. That final order has been stayed by this honorable court.
And your lordship, the subject matter of this case, whether promotion can be granted pending vigilance proceedings, is covered by a division bench judgment of this honorable court in Joseph Barik. If I may be permitted.
No. We will not go into that.
Grateful, your lordship. As your lordship.
We will not go into. This can be done. Not this. What is TP?
Tata Power Central Odisha Distribution Limited.
The present appellant.
Private organization.
Hello.
It's a distribution company, your lordship, under the Electricity Act. Distribution license.
Tata Power Central Odisha Distribution Company Limited. And its officials have referred this intra-court appeal, putting to challenge an order dated 17/12/2021, passed by a learned single judge of this court in WPC number 39224 of 2021. Thereby, the learned single judge has disposed of the writ application with certain observations. Certain observation on the point of grant of promotion during the pendency of vigilance proceeding initiated against the respondent in the year 2019. So stop. The short point which has been argued on behalf of the appellant in the present appeal is that the impugned order dated 17/12/2021 was passed by the learned single judge on the very first day when the matter was listed, comma, without issuing notice to the appellant, who was a necessary party. Stocky contends that learned single judge ought to have given the appellants an opportunity of hearing by issuance of notice. Next. Mr. B. Mansingh,
My lord.
learned counsel for the respondent, on the other hand, has submitted that the impugned order passed by the learned single judge is based on sound legal reasoning and does not require interference. So stop. He submits that on the sole ground of pendency of a vigilance proceeding, the petitioner has been made to suffer, the respondent has been made to suffer, and in that background, the learned single judge has rightly directed that long pendency of such proceeding should not come in way of grant of motion. This is your submission. Next. Be that as it may, comma, we find force in this submission advanced on behalf of the appellant. So stop. The impugned order passed by the learned single judge requires interference on the sole ground that the same was passed without on the very first day without issuance of notice to the necessary parties who are the appellants herein. Stop. Accordingly, the impugned order dated 17/12/2021 passed in WPC number 39224 of 2021 is hereby set aside. The set aside and WP bracketed C number 39224 of 2024. 2021 is directed to be restored to its original file. So stop. Let the said matter be listed before appropriate bench, single bench, as per the roster. So this appeal stands allowed with the aforesaid observation and observation. That's all.
order passed.
Interim order.
Your Lordship's order, the interim order was there in this case, so that
Interim
may be
order
vacated.
stands vacated.
And one thing may I submit before Your Lordship? The matter was had in their presence. Now they denied. And the punishment department has issued, that has been stayed by the High Court. My Lord is saying that no, that has not been stayed. And by virtue of this order, my Lord, I filed an affidavit. Number of cases has been implemented by giving respect to this honorable single judge order. That is there, my affidavit.
Procedure is
My
prescribed under the High Court rules also everywhere.
same order has been complied. Number of cases that I have filed in my affidavit. That is also. All right, all right. Item 31, public.
My lord, I am the
May I
respondent.
please your lordship?
Yes.
My lord, here in this appeal, lease granted in favor of 4 private respondent number 1 to 4, as homesteadless is under challenge, or this was the honorable single judge has held that the collector has exceeded its jurisdiction and passed the order. For that, may I take your lordship page 37 of the brief, my lord. Total 4 persons, they belong to one family, 1.5 decimal of land each in favor of the each member. In total, lease has been granted, and this is a passage road to the main public road. That's why this has been said that it is not available to be settled. However, when it was assembled before the single judge, it was held that the collector has exceeded its jurisdiction. But my contention would be the collector has not exceeded its jurisdiction, as I was drawing your lordship's attention to page 37. This is the order passed by the collector. Basing upon page 37.
Page 37 annexure.
Annexure 1, my lord. It's a part of Annexure 1, my lord. In fact, Annexure 1 starts from page 20, but I am drawing your lordship attention to page 37. This was under challenge before the honorable single judge, my lord.
Order dated 25th January 2021.
Published. That is the order. Your lordship may mark this miscase, the first line itself. This miscase arises out of WPC number 19877 of 2019, filed by the petitioner, praying to evict the illegal encroacher of government land from plot number 3176, 6 decimal, Kisam. It is within bracket Rasta. Rasta is a vernacular term. It is an English term would be road. In connection with Khata number such and such, the Honorable High Court have directed the Collector Kendrapada to consider and dispose of the petitioner representation dated 5/7/2019 under Annexure 10 as expeditiously as possible, preferable within a period of 4 months from the date of receipt of copy of this order. Basing on this order, my lord, the collector has passed, and he has noted that these 4 persons are the serial encroachers, and he has at page exactly, my lord, page 42, he has noted thrice encroachment cases was instituted. Either it is dropped or they were directed to be evicted. Ultimately, when lease was granted on 16 March 2019, later on also, upon detection of the fact that the family is having 13.63 acre of land, this lease was cancelled. These all facts was noted by the learned collector and hold that they are liable to be evicted. The concluding part, if your lordship permit, page
He was
43,
exercising which power?
the collector was exercising the power. The one PIL was filed, as your lordship.
Whether the collector was exercising any statutory power or the power vested by the High Court.
There was a representation was pending before the collector.
Sir, if a representation is placed before the superintendent of police, then can he decide a suit?
No, my lord. No, my lord.
Therefore, we are putting this question.
My lord.
Whether he was exercising any statutory power, the collector, or he was exercising his power in the light of some order passed by this court.
In the light of the order passed by this honorable court.
So, can the High Court confer a jurisdiction upon any authority which he does not have?
My lord, he has not in fact exercised any jurisdiction. He has reflected that lease has already been cancelled. That much he has done. He has not said
He has
that.
not passed any order.
No,
So
no.
This is what we wanted to know.
He
That's
only
all.
said, my lord, for that, if your lordship, page 43, one paragraph would be page 43, my lord, second paragraph. May I read, my lord?
Yes.
When the fact stood thus, Tahsildar Ali initiated so motum case number 27799, 7899, such and such, respectively, as per section 109 of Odisha Mutation Manual against the above named patta holders, and considering the economic condition and landed properties owned by them, cancel the order passed on dated 9/10/2019. Simultaneously cancel the patta issued to them in lease case number such and such. So this was cancelled. This order was passed in 21. He has reflected that since 2019 November, the patta has already been cancelled. And it has not been, by then it was also not under challenge also. That is what he has reflected. And concluding paragraph, he said it's a rasta, could not have been that much.
So what is the order passed by the?
The Honorable Single Judge took note of the last portion of the order, very same page, my lord, where the learned collector has said, since it's a rasta land, could not have been settled. After noting that it has already been cancelled, he said it could not have been settled, being that much. The court has learned, Honorable Single Judge, sir, he has assumed revisional or appellate jurisdiction. In fact, by 2019, it was already cancelled. That was not in existence. He has not cancelled. That's a fact. And fact remains, under the Act, homesteadless has been defined under the OPLE Act. 1 acre of land is the maximum area. If someone possesses less than that, is entitled. Along with that, if he is having no homestead plot. But here in this case, twice it has been held that they have 1.7 acre of land beside the road, which can be converted under the Odisha Land Reforms Act for being used at homestead. And in total, the family is having 13.63 acres of land. So under no consideration, they could have been termed as homesteadless. There are two considerations, landless and homesteadless. Question of landless doesn't arise. The homesteadless also doesn't apply here, my lord. If your lordship permit me, Odisha Prevention of Land Encroachment Act, my lord.
Other side is appearing.
I am for the respondent number 1 to 4, my lord.
Please, sir. Please, sir. Yes.
I am drawing your lordship's attention to section 7, subsection 2B, which is the relevant, my lord. Clause B of subsection 2, section 7. I think it is at page 12. If the may I place, my lord?
Yes.
Where any land is in unauthorized occupation of a homesteadless person, which is being utilized by him as a homestead, the Tahsildar shall, instead of evicting such person, settle the same with him. So, however, that the land so settled with him shall not exceed 1/10 of an acre. The proviso to the very provision says, provided that no such settlement shall be made in land belonging to any of the following categories, namely lands recorded as gochar, rakhit or sarvasadharan in the record of right. B, lands which are set apart for common use of the village, used as house site, backyard, temple. So these are used by as a passage by the villagers. So far as the homestead less, this has also been defined under the very same act also.
No, but who are you?
My lord, I am the person, villager, who have instituted the PIL, because we the villagers are using this passage of land to approach the main road. That is also the categorical finding of the Tahsildar, as well as when the matter was brought up before the collector, the finding that it is recorded in the record of right as Rasta, Kisam.
You were party in the writ proceeding.
Yes, ma'am. In the writ petition, they have not made me party, I intervened. My intervention was allowed. The homesteadless has been also defined, with your lordship permission, means a person who, together with all the members of his family who are living with him in common mess, does not have any homestead land anywhere in the state and owes less than 1 standard acre of land other than homestead. So here they possess 13.63 acres of land. The condition required that to be torn as the homesteadless, it should be less than 1 acre. This is one aspect. And so far as that standard acre, this has been defined under Odisha Land Reforms Act. I think may not be necessary because these are class of property, how it used to be. 1 standard acre doesn't quantify 1. In terms of the variety of the land, it increases. Even taking into consideration that interpretation under the Whaler Act also.
State did not prefer any appeal.
State didn't prefer appeal, but in the writ petition, a specific counter-affidavit was filed by the state stating that these are the aspects. The 13.63 acre land, whatever, my lord, with your lordship permission, I have urged by now, is also based on the counter-affidavit filed by the state, which is also on record. I have brought on that page 95 of the present brief, my lord. I have brought on the record the counter-affidavit filed by the state. But Honorable Single Judge said that the collector has passed the cancellation of lease by exceeding his jurisdiction. In fact, it was not by the collector. It was by the Tahsildar in November 2019. And the collector took up the representation disposal process.
No, the prima facie, we are of the view that you don't have any locus standi to challenge. So it's a dispute between these, primarily between the estate and the.
My lord,
whether you should be allowed to
my lord,
pursue this appeal only because you intervened and your intervention.
Not intervene in the writ petition for the first time. We, the person, have filed the PIL.
We understand that.
PIL also we have filed.
PIL is nothing. PIL does not make you entitled to enter into private disputes.
And page 87 also, we have also appeared before the Tahsildar. This, when the cancellation was also made, that was also brought on record also. It is not for the first time we are agitating or behind the back of the person concerns, we are agitating the issue. Issue is that we consistently, the villagers are opposing the encroachment of the passage, because this will lead to blockage of the passage to the main road. And moreover, they are not coming under the purview of the land homesteadlessness. That is what is my concern.
Yes, so it's for the estate.
And clear for the state.
So you must be very happy with the order.
And also, if the lease has been cancelled, according to him, the lease has been cancelled. So that the impugned order reveals. So there is no chance. So then the order is also that we will evict them. So how the petitioner is prejudiced? Lease is cancelled. That is also given in our counter-affidavit, which I find. This is a private dispute because these villagers, they filed the writ petition praying inter alia that they should be evicted, these private respondents. There the Honorable High Court has directed to dispose of the representation. The representation was heard by the collector in presence of both the parties. And the impugned order which was subjected to challenge in the writ petition, that was passed, the exhaustive order was passed by the collector. That is, your Lordship may kindly see the last portion of that order.
Sorry, but the collector's order has been set aside.
In the writ petition, yes. But the collector's order is that the Tahsildar RE is directed to make eviction following the procedure as per the OPL Act, the rules made thereunder. That is set aside by the, that is why whatever the Lordship will direct.
The cancellation of lease order has not been touched by the impugned order. Honorable Court has only set aside the order passed by the collector. So far as this annexure 6, this was also assayed, but it was not touched upon.
Yes, amendment.
Yes, please. Please make a submission.
My lord, first of all, my respectful submission is that for the self-same region, the same appellant also went to the civil court, civil judge senior division Potamundi. This is also running there. And again, they have challenged him before the High Court. Civil case is pursuing by these appellants, Miller.
It is pending.
It is pending.
And when was the PIL filed?
My lord?
When was the PIL filed?
PIL.
It was filed on
2019. 19877 of
It is a private litigation, but in the guise of PIL, he has filed. My lord,
It was filed
let
on
me read the entire judgment. The judgment is correctly pronounced by the Honorable Single Judge. How they have
was
dictated.
the PIL filed?
24th July 2019.
So did you mention in the PIL that suit is pending?
That I have to check up.
No.
Then be ready for exemplary cost.
Even not disclosed before the collector, which I find from the order.
The order.
No, nowhere he has disclosed.
No, my lord, the PIL is checked up, but it was based upon the that no lease has been granted. That's why the PIL, along with the petitioner, 13 other persons have filed the PIL, my lord.
Silent about that.
That you have suppressed.
And this was not also urged before the either the PIL court or before the honorable single
It's a
judge.
serious matter.
My lord. But 13 persons they have joined.
13 Gangadhar Sahu was there in PIL or not?
Gangadhar Sahu.
Sarveshwar Sahu, Narayan Sahu, Divankar Sahu,
Yes,
Sudhakar Sahu.
Narayan is the.
Gangadhar Sahu was not a party.
Gang-
But some of them, as it appears, some of them.
And it's a misuse of the process.
There are common persons, a party in the suit as well as. in
Misuse of the process. You can bring this on record. By file an affidavit, bring this on record, we will impose exemplary cost upon them.
My lord.
It has been pointed out by learned counsel for the respondents that the public interest litigation which was filed by the appellants and the order passed in the said PIL. Then in the PIL which was filed by the appellant, the fact that they had also filed a suit with respect to the same subject matter was intentionally suppressed. Full stop. Certified copy of the print of the suit has been produced before us for our perusal. Full stop. The court takes serious note of the matter and will hear it on the next day, 2 weeks. So by the said date, learned counsel for the respondent shall be at liberty to bring on record a copy of the certified copy of the plaint after serving a copy upon learned counsel for the appellant.
I have checked also the date that is earlier filed. I have checked from my senior.
Very serious.
No, I have checked, my lord. I have to be very fair, at least looking at the document.
We understand that you are a fair counsel. That we know. That we don't have any doubts about your bona fide.
Once it is brought to notice, my lord, I have to assist your lordship, my lord.
If you want to press this appeal, it may be.
No, under the circumstances, there is no reason to press because they let the civil court take.
My lord,
its
the
own-
matter will be listed on.
No, he is withdrawing it. He is not pressing. Learned counsel, learned counsel appearing on behalf of the appellant after having realized that a suit is pending in respect of the same subject matter in the court of
Civil Judge Junior Division, Patna Mundai.
learned civil judge junior division Patna Mundai.
Senior Division. my lord,
Senior
senior.
Division Patna Mundai chooses not to press the present appeal and pursue the appeal to stop. This appeal is accordingly dismissed as not pressed.
Item 32.
32, my lord, I'm drawing your lordship's attention to the last order dated 19th February 2024. And as per the direct note, counter affidavit agent date has been filed. Let me proceed the matter.
We may seek further time.
Before I,
Where is the order?
the order is
We have not
19th,
filed the
19th February 2024. The last sentence one.
It is a fact that we had sought for adjournment and we have not filed the counter affidavit. Because instruction is, I have given letter, they will give it within 1 week. If your lordship will grant me
May-
for the time of 2 weeks, or your lordship may hear it on the basis of the materials available on.
We'll hear it because last chance was given.
Yes.
And before I go to the impugned order, may I just draw your lordship's attention to page 51 to 53. I'm just taking the facts in very brief. That's the record of right, and I've given the translated copy. That's also on record.
Page?
Page 51 to 53. That is in Odia. I've given a translated copy, my lord, and submitted a translated copy on 1st of February 2023. That's much.
Annexure 151.
Yes, my lord. Annexure 1 to the writ of
That
petition.
is ROR.
Yes, my lord. Has your lordship got the translated copy, or I'll
Flag A. Flag A. He is drawing attention to flag A, which is translated copy of the annexure.
I have, my lord, instant another copy, your lordship.
It is there.
My lordship, can you see the name of the occupant and the Royat's name? Golbadan Pradhan and Kesav Pradhan.
Now, what is your point?
My lord, yes, I'm coming. So this is admittedly the joint family property, and as per the ROR, the total extent of land is 27 acre odd. So two of the shareholders, they wanted to alienate their share in the property, and they executed a deed in that. This deed was refused to be registered on the ground that it discloses the exact plot with boundary particulars. That's why the register refuses. I followed it in appeal, the same result. And in the impugned order, the Honorable Single Judge has added one more ground to that, that's saying that this violates section 22A C of the Odisha Registration Act. Your lordship, kindly have that. Two grounds, the Honorable Single Judge has said it's violates section 44 of the Transfer of Property Act. Hence, the mandate of section 22A C has been violated. (22A) has been brought in by way of an amendment in the year 2014. 22A(1)(c). That's the Registration Act.
Yes.
See, any instrument relating to transfer of immovable property, the alienation or transfer of which is prohibited under the state or central act. So, Honorable Single Judge, and now I'm taking a lordship to the impugned order. The Honorable Single Judge at page 29, I'm taking to page 30 of the second sentence, my lord, begin with in the instant case. In the instant case, although the petitioner have right to alienate their share in the joint family, but they have no right to alienate the specific parcel of land as provided in section 44A of the TP Act
Thus, the registering officer before the registration has duly examined as to whether the petitioner have right to transfer the specific parcel of land which is admittedly absent in the instant case. There is no material to establish that said.
So who is appearing for the private party?
No, my private party is my vendor, my vendee. So
No, but it's a joint family, no?
then
Yes.
that's only, I am not making others are parties.
Right.
No, my lord, I have only against the authorities. It's a joint family property.
No, but it's a joint family property, but the members of the joint family may also have something to say.
But my case is that they are not coming forward, they are not consenting. I am selling my share. Under section 44, I am drawing a lordship letters. So it's permissible. So where if they one lordship candidate section 44, this is the admitted position. Section 44 of the Transfer Property Act.
Yes, the reasoning does not appear to be correct, Mr. Counsel.
My lord, let me place if your lordship will permit. It is a joint family property and big chunk of land, 27 or 22 acres. There are numerous multiple co-sharers. Admittedly, there is no partition by meets and bounds. The record of rights stands jointly in favor of all the co-sharers.
You are arguing in whose favor?
No. Why the sub-registrar has denied the registration? That is what I am placing before your lordship. Because the other co-sharer, there is no partition, so you cannot alienate a specific portion.
You cannot alienate your right.
Yes, my lord.
But you have a duty to register any document which is presented before you.
But
these are two separate things.
The view of the honorable single judge is the
view may not be correct.
No, that is
why is challenging.
That is correct. But my response submission is that it is the bounden duty of the sub-registrar that some semblance of right.
Where is that?
Cannot be adjudicated.
Because it will be prejudicial to the interest of the other
No, it
co-sharers.
will not be prejudicial.
Is it his, is he vested with that power to exercise?
Because, yes, section 44 prohibits that any undivided portion cannot be alienated.
Just a minute.
Which?
Where one of two or more co-owners of immovable are legally competent to that behalf transfer his share of such property or any interest therein, the transferee acquires as to such share to interest, and so far as is necessary to give effect to the transferee right to joint possession or other common or part enjoyment of the property and to enforce a partition of the same, but subject to the condition.
You are making us read Transfer of Property Act.
Yes, my lord.
So if the registrar will apply Transfer of Property Act.
That's exactly.
Now, section sub-registrar has, because here the case is that he can transfer.
We understand.
But a specific portion with boundary.
A specific portion, the only bar which is there under the Registration Act is under section 22A.
Yes.
That too introduced in 2014.
Yes.
So before 2014, the registrar had a duty to register any document presented before him. How can he decline? And that is the Supreme Court's decision.
My response submission is that there is no legal impediment for registration of a property which belong to a joint family at the instance of one co-sharer. But a definite share with boundary and sketch map, that is not allowed as per the.
Who is he to question?
Because that is not allotted to him.
My God.
That is the view. Because
the document is presented after this amendment.
Yes, madam.
Yes, recently presented.
Which one?
He
even 22AC.
No, that's
section 40.
There's no prohibition.
not prohibited. It's
Just
a,
a
it
minute.
allows.
This is a if it is barred by any sentence, then my responsible submission is.
Just a minute, let us understand.
Yes, ma'am. Sorry.
Where is the bar under 44?
Yes, that is bar is you can sell the undivided share, not a specific portion.
Yes, also amended.
And in so far as that,
Subsection 2 of section 22A,
Yes, madam. If it is, there is a bar in any central act,
State Act also.
state act or central act, both.
No, come to subsection 2 of section 22A.
Notwithstanding anything contained in this act, the registering officer shall not register any document presented to him for registration unless the transferor produce the record of right for the satisfaction of the registering officer that such transferor has right, title, interest over the property so transferred. Here he is the recorded owner, but one of the recorded owner. There are multiple co-sharers who have been recorded along with him as the co-owners in respect of the entire property, out of which he is unilaterally selling a portion with boundary and sketch map that saying that this is my
To
property.
the satisfaction of the sub-registrar, he could not show that this portion he has acquired right, title and interest.
Yes,
but I am not required to, my submission is I am not required to give, and I admit there is no partition by midst and bound, and there is no partition by court's order.
Mister, the question is,
Yes, madam.
the situation was different before introduction of 22A.
Madam.
Section 22A has introduced so many things. So the law which you are relying on, the Supreme Court's decision, that must not have taken note of these provisions under the Registration Act.
I'll go to 22A in this way. Lordship, can you see that says any instrument relating to immovable transfer, the alienation of transfer of which is prohibited under the state or central. Now I'm giving example of two acts.
No, why are you reading central? Why you read 22A2?
Yes, madam. Notwithstanding anything contained, the registering officer shall not register the document presented to him.
22 capital A subsection 2.
Well, that's what I'm saying.
Yes.
Notwithstanding anything contained in this act, the registering officer shall not register any document presented to him for registration unless the transferor produce the record of right for satisfaction of the registering officer that such transferor has right, title, and interest over the property so transferred. So I have produced that. I have produced that.
No.
Yes, my lord. The record of right I have produced.
The record of right, no, it's not enough.
No, no.
You will have to satisfy him that you have right, title, and interest over the piece of land.
Yes.
In respect to which you are executing.
My lord, then it will be an adjudicating function.
Yes.
Then it will be an adjudicating.
This is what 22.
And this 22A has been diluted by our own High Court in Dhabala Prasad case.
All right, let us.
That's one. That has been diluted, and it said no requirement of production of any record of right.
Let us see.
Well, that's I'm open. That's settled by, and they have changed it also.
Where is that? Let us see.
That I have not brought up.
That I have not brought. Then don't argue. We are also. I had also not seen this provision.
And all these judgments which I am relying upon.
If you can see this Dhabala Prasad.
I am just saying that central statute.
That is before 2014.
No, what?
That Bhaval is before 2014 or after 2014?
That the
Which,
honorable-
my lord?
You are relying.
Dhaval Prasad is actually questioning this 22A. After coming into force, it has been agitated before this
All
court
right, bring that decision.
twice and one
Bring that
another
decision.
and another judgment after this 22A I have annexed here. This is also after post amendment.
What is that?
That's Sitarani Rotha.
Where is that?
That's the judgment group last flag F, I believe.
In page 8.
Flag F.
Yes, ma'am.
Top.
So here, my lord, question is this, my lord, 22 of the Registration Act and 24 of the Odisha Registration.
Also, what is
Rule.
the citation?
My lord?
What is the citation?
Sitarani Rotha versus, may I just?
That is 2015 CLT.
2015 ACC online, Odisha 666. This is also registered on the basis of 22A.
Here, record of right was published in the name of petitioner in mutation case number such and such, indicating her share as 7/16 of the plots mentioned thereunder. Sitarani Rath
It's a
case.
joint.
Fact is something different.
Jointly
Maybe,
mutation
maybe,
cannot.
sir, maybe,
That's the share.
The fact shows that it has already been mutated in her
Yes,
favor.
mutated along with mutation.
share has been
Share has
defined.
been defined.
No.
Defined.
That's it.
In
My
the
hold it this
government
way.
record.
So,
Mutation, every other legal heirs name was there in the record of right. Other legal heirs name was there in the record of right. Fact is not different.
You are not satisfied.
Well, I'm just drawing your lord's attention to that Bhartu. That Punjab full bench decision. That
Where
what
is
is the effect of section 44?
Punjab full bench.
Yes, ma'am. Then it has gone to the apex court has approved
No,
it.
no, what was the law in Punjab?
Well, yes, the law was there is a person alienated a person.
What was the law in
Exactly.
Punjab? You have a provision in the nature of section 22A introduced in
registration.
2014.
No, well, it was not. It was in the premise. It was in the premise. No, it was in the premise that whether under section 44 a specific.
Mr. Rath, Registration Act, Central Act,
Yes, madam.
Odisha Amendment is there.
Yes, madam.
We have to follow Odisha Amendment or we have to follow Central Amendment.
No, my lord, what is the ratio is I am saying that under section 44 a selling of specific person.
Ratio
Lordship, allow
is to be.
I understand your
To
lordship.
be within the parameters which is defined in the statute, particular statute.
I understand your lordship's query. The only thing that the honorable single judge has denied that my deed violates section 44 of the Transfer of Property Act because of disclosure of specific parcels of land with boundary.
Have you challenged?
My lord, may I just, this is what section 44 has been analyzed by the honorable apex court to mean that yes, even specific person does not take away the right of other co-personers and they can always sue and the transferee will not.
The Supreme Court's decision is based on the Registration Act in the absence of any provision akin to section 22A.
No,
that is the different, and this is peculiar provision under the Odisha. This provision is not there in any of the enactments, to my knowledge.
In fact, Rajasthan, it was tried once in that public policy. I have also given that judgment in the Supreme Court, Honorable Apex Court. They have put this word called public policy. And the Honorable Apex Court has dealt it this way, that registration is nothing but a administrative function and indexing.
You are right. But here there is a provision.
But even they have introduced that provision of 22A in 2014, which was subject matter of challenge. And there, their lordship has held this way. That we have noticed henceforth, the Honorable Apex Court has, while striking down it, that they say it will amount to
Have
conform.
you challenged the virus?
Yes, virus is also pending before your lordship.
Where?
In Sudhir Khuntia matter, I have challenged.
That will be taken up after this, this
But-
matter.
My lord, that is also challenged. So,
All right,
and several, and
Mr. Unless the virus is decided, you cannot succeed. The provision is there against you. If you want the case to be decided now, we'll decide tomorrow,
my lord, let them, that virus as
as you wish.
and then
The
it's at the end of the
claim
I will
of
contract.
the
Case number.
appellate had presented. You had presented sealed deed,
Yes, ma'am.
had presented a sealed deed for registration of part of his joint family property before partition in the family by meets and bounds. First off, the registrar, sub-registrar has declined. The sub-registrar had declined to register the document by referring to the provision under section 22 capital A of the Registration Act 1908. First off, learned single judge.
My lord, that order was confirmed by the appellate court, district register.
The said order came to be affirmed by order of the registering authority declining to register the document came to be affirmed by the appellate authority, that is the collector of which district?
Register, the district register Sambalpur in Miss Appeal number 04 of
District.
2022.
District registrar, not district magistrate. District registrar Sambalpur. The petitioner, the appellant,
Thereafter,
Question. sorry, the petitioner question the correctness of the said order. You filed the appeal,
Yes.
writ petition.
Yes, ma'am.
The petitioner challenged the order of the sub-registrar and the district registrar orders before this court, giving rise to, by filing a writ petition,
19196
giving rise to CWJC number 19196 of
2020
2022, which has been dismissed,
on
Yes.
8th September 2020.
which came to be dismissed on 8/9/2022.
September 22.
This appeal has been preferred. This intra-court appeal has been preferred against the said order of the learned single judge. First off, next, we are of the prima facie view that there being specific provision under section 22 capital A of the Registration Act, which has been introduced in 2014
By way of amendment.
by way of amendment, comma, the rejection to register the document is justified. First off, learned counsel for the appellant, after having argued the appeal at length, has submitted that the validity of section 22A has been challenged, is under challenge in WP.
WP number is not open.
No, you'll have to give it.
My lord, but Sudhir Khuntia just versus state, that petition which I am appearing.
So I have remembered that. There are several petitions. One of them is this. Sudhir Khuntia. In course of the day, I'm trying to.
Please give it, otherwise the order shall remain incomplete. In case of, stop. He submits that he shall be pressing this appeal after the valid question or validity of section 22 capital A is decided. Stop. वो जरा देना. Expedite. Stop. List this appeal on 6 weeks. Stop. In the meanwhile, we will see what can be done in that case.
My lord, that can be expedited, listed on.
Sudhir Khutia.
Yes, sir.
What's the state?
WPC number I'm supplying.
The virus, hai?
Yes.
Virus.
He is taking
I am
Sudhir Khuntia. So the Sudhir Khuntia.
Yes, I am the counsel there, so I.
How many persons we don't know. Therefore, whether it relates to
I am the
virus.
counsel there, so I remember the
The
chapter.
council,
No, in 2014 you challenged.
Yes, my lord.
So
It is there.
that is the
His
only
name is
name.
there.
That is the only name.
There are several other matters have been tagged.
No, no.
The main matter is the WPC number 162
And
WPC number 929.
how many?
10 to 15.
All right. All right.
Take a
Catch up
copy.
cases.
You can take a copy.
Maybe, my lord.
Another.
If that matter can be listed.
That will make a mention, we'll see. Yes.
Item 33.
Please, Your Lordship, I'm on virtual. The state has to file a counter, undertaken to file a counter.
Yes. Why counter in appeal, Mr.?
Your Lordship directed because here is a case where the case was disposed of by the Lord and single judge on the ground that I participated in, that the person those are participated in the advertisement, that they stood to challenge. Because the law is that one whistle is made, you cannot change the rule. But my case is I have never appeared in the test that Lordship will get from the order dated 18/4/2023. Lordship's order dated 18/4/2023. Therefore, Lordship keep it. If they cannot, they will not file and the appeal is not required a counter. Let us keep it next week and argue on merit. I've decided I've not read the brief because of the fact that they are undertaking to file a counter.
Yes. Will you file counter affidavits?
I'll file a short counter. Actually, probably the opposite part number 5 wanted to file counter before my lord.
Who is opposite party?
National Council for Teachers Education.
Yes, he's their master. He has his decision and his disposition. So far the appointment is concerned is a paramount consideration. National Council of Teacher Education stipulation for appointment to the post in question is the paramount consideration.
Oh.
Let them keep any date, my lord. If they don't want to file counter, I can argue and let them dispose of the matter.
No, but the state had taken time to file counter affidavit,
Yes,
not
yes.
the NCT.
No, I am for the opposite party 1 and 3.
Every time state respondents.
Madam may permit me 7 to 10 days time. I'll file a short counter.
All right, pay some cost. 2 weeks time is allowed for the state to file counter affidavit, subject to payment of cost of ₹2,000 to the appellant. So stop. The cost is being imposed, keeping in mind the fact that
several adjournments. We have granted at the instance of the estate to file the counter affidavit. File the counter affidavit.
Obliged, ma'am.
My lords, I have instructions to appear for the Public Service Commission. My lord, I have only one submission. In the lead writ petition, there were several private respondents. They have not been made parties in this writ appeal.
Maybe.
Your lordship, please.
Item 34.
May I please? The petitioner, my lords, the short facts of the case is, my lords, the petitioner husband was an employee of Odisha State Electricity Board, and he was expired, my lord, in the 1991. At that time, my lords, he was in a non-pensionary category employee, my lords. After Odisha Electricity Reforms Act came into force in 1995, that is GRIDCO and OPTCL came into force, and in OPTCL, my lord, by the Annexure 1, my lords, at paragraph by the Annexure 1 in 2009, issued an order that the person, those who are non-pensionary category, if they will come to the pensionary category, then they will refund the Provident Fund with gratuity and 9% interest, along with an undertaking. A format of undertaking is there. As I was residing in the interior state of the West Bengal, I applied in the late, and they have accepted my form, and I kindly glance to annexure, that is the impugned order, and they have accepted. Then in the counter, they have accepted that they have received the option form. But by the annexure 4, the single judge, that is a paragraph page.
Order of the single judge was passed when?
Order of the single judge was passed in 2020.
2020.
That, my lord, that is.
Another question. My question was incorrect. When was the order passed by the learned single judge in the writ proceeding?
Writ proceeding in 2020. That is by the annexure 4, my lords.
18 to 2020.
18 to 2020.
All right.
My lords, that is turn to page 25. Page 25, the second paragraph. Second subparagraph.
Then you file a review application.
Then I filed a review application, because I filed a review application only one ground, my lords. That, my lords, that my option form was available at annexure 7 at page 24. That was lost sight of the fact, and my lords, single judge that passed that order, that option form was not filed, which was accepted, which in the counter, my lords, they have accepted that we have accepted the option form. That is my only stipulation, lords. That is, my lords, that is just paragraph number page 25, my lords. Page 25, second subparagraph. Considering the rival contention of the parties, got it? This court finds that a petitioner has a sustainable claim on the ground of filing of delayed application for residing outside the state, there being no adequate circulation involving the circular at annexure 5. This court here finds at a paragraph number 4 read as follows. That is, my lords, that is for the employees who have exercised their option and willing to come to OPTCL pension regulation shall deposit the employee's share of Provident Fund, differential industrial gratuity already received, with 9% interest up to the date in shape of account by bankrupt drawn in any nationalized bank in favor of the director, so and so, OPTCL, or submit an affidavit certificate regarding adjustment and retention of such amount from the pensionary benefits or availing benefit. That is the format with an undertaking. I submitted the undertaking at annexure 7 at page 24, my lords, which was accepted, my lords, in the onto a counter, my lords. In the counter, my lords, that at annexure 3 at page, my lords, at paragraph number 8, page 21, my lords. Page 21.
Annexure 3.
Annexure 3.
Page 21.
Page 21.
Yes.
Paragraph number 3, paragraph number 8, last line. Annexure 7 is received on 11/9/2010. Whereas the single judge, my lords, pointed out that option form was not available. So I filed a review application. Paragraph number 8, my lords, paragraph number 8, last line. Annexure 7 is received on 11/8/2010.
But entire sentence, if you read,
That as per order or
that as
annex-
per the order as at Annexure 5,
yes,
the option is to be submitted by 30th April 2009, but no application has.
received from the
Then
petitioner
received
within a
from the-
prescribed time.
Ah.
That manner that therefore
Therefore, the option was to be exercised before 34/2009.
yes, madam.
You did not do that,
I did not do
and
yes.
it was done on 11/8/2010.
No, it was done in 29/7/2010.
There was no extension of time.
There's no extension of time, but the single judge hold, my lords. Single judge hold that this court finds that a petitioner has a sustainable claim on the ground of filing delayed application for a residing outside the state, and there being no adequate circulation involving the circular at Annexure 5. That was allowed, my lords. But only, my lords, that is rejected because option for, my lords, that was not available in the writ application. And in the review application, I specifically pointed out that Annexure 7 at page 24, that option form was there, in the undertaking form was there. I have filed. That was lost sight of the fact, my lords. The Honorable Court has lost sight of the fact, and that was review application was rejected.
No, but if the decision of the your employer
Yes,
was that you should file your option by 34/2009,
yes.
how could that be extended?
That was extended because that was not widely circulated because I was residing in the interior state of West Bengal, my lords.
Suppose you go to the United States and you come after 5 years from there and you take a plea that even you did not have the access to Sunmark
Because that office order, my
in
lord,
America.
if the office order was not circulated, my lord, why?
This order is to be made public, that's all.
That
Office
was,
order was made public. How this date can be extended?
that was extended by the single judgment,
Huh?
but rejected only on the ground that
was
option.
That was, that was extended, that was wrong.
Because, my lords, that is one judgment, my lords, that is if the
What is there in the judgment?
because that is what not published in the official gazette. That is only, my lord, that is office order was published. That is, my lord, that is Central Excise Rules, notification on right, when becomes effective, publication of notification through gazette. Mere printing of it in the gazette is not sufficient. It becomes effective from the date it is made available to the public. Because this is an office order, issued by the OPTCL, my lords. That was not published in the official gazette. So I do not, because I was residing in the interior part of the West Bengal, my lords, in the remote village,
So when was that issued?
my lords, that notification, my lords, that office order, my lords. Office order was issued, my lords, that is by the Annexure 1 at page, my lords, that is on 16/2/2009. That one office order was issued, my lords.
Difficult, Mr.
And only, my lord, the single judge rejected only on the ground that option, that in the undertaking, your undertaking was not available in the writ application. That is only, my lord, only ground that has been rejected.
Not your undertaking, your option.
Yes, option form. Yes, I have submitted the option. I have specifically heard that in the Annexure 7 at page 24, I have submitted the option with an undertaking, and that was lost sight of the fact amendments.
All right. That's all. Sorry. This is an intra-court appeal putting to challenge an order dated 18/2/2020 passed by a learned single judge of this court in WPC number 18691 of 2012, whereby the petitioner's writ petition has been dismissed. Also, the petitioner had preferred a review application seeking review of the said order dated 18/2/2020, giving rise to RV WPET number 183 of 2020, which also came to be dismissed by the learned single judge on 11/10/2022.
Yes.
The said order is also under challenge in the present intra-court appeal, in the present appeal. So stop. Short facts not in dispute for the present adjudication are that the petitioner's husband was an employee under what is?
Non-pensionary category.
Huh?
Non-pensionary category. Petitioner husband Malak was an employee of Odisha State Electricity Board.
Orissa State Electricity Board, bracketed, since dissolved. It has been dissolved. Full stop. The petitioner claimed that after the death of her husband, who had already retired,
We're already dead, man.
he was not, he died in harness or what?
Yes, man. And died in harness.
Tell again.
The applicant stated that after the death of her husband,
Death of her husband, she had exercised option under scheme for pension, scheme for extension of benefits, pensionary benefits. So stop. It is also not in dispute that such option was to be, that the cutoff date for exercising such option was
11/34/2009.
34/2009. So the petitioner had admittedly not submitted and not exercised the option, requisite option within the stipulated time, rather much after that, on 11/8/2010.
Yes.
So stop. The petitioner pleaded in the as the petitioner was denied the benefit of pension, she approached this court by filing the said writ petition, which has been dismissed. A specific stand was taken on behalf of the state of Bihar in its counter-affidavit that the appellant's husband, that the appellant had exercised the option on 11/8/2010. This was the stand.
Yes.
Stop. It is the appellant's case, it was the appellant's case in the writ proceeding that he was unaware of the scheme as he was residing at a place far away from Odisha.
West Bengal.
He was residing in West Bengal and therefore he could not know about the scheme of pension and the cutoff date fixed for exercising the option. So stop. The single judge dismissed the writ petition, taking into account the admitted facts and the attending circumstances. So stop. As has been noted above, comma, a review petition also came to be dismissed. Next. Mr. Pandal and Mr.
Dinesh
Counsel appearing on behalf of the appellant has very passionately submitted that the learned single judge held in his order that the the appellant had a sustainable claim on the ground of filing of delayed application as he was residing outside the estate and there was no adequate circulation of the scheme for extending pensionary benefits to the employees of OPTCL,
Odisha Power Transmission.
OPTCL. Oh, stop. He submits that the learned single judge, however, committed an error of record. Where is that error?
It is, my lords, at a page 26, my lords, sixth line from top.
Page 25 is the order.
No, then that page 26, my lords,
Page 26.
sixth line from the top, my lords. Perusal of the pleadings. And consideration of considering the submission of Mr. Punda, Lord Counsel, the petitioner, this court nowhere finds that any statement coming forth regarding either deposit
Did you
of the
deposit the required amount?
Yes, that undertaking, my lords, was available in the annexure 7.
No, that undertaking was not required.
Yes, my lord, that is in the format, my lord. That is annexure 1 is the format. My lords. Annexure 1 is the undertaking.
Oh,
of the
no. Sorry.
that is the format, my lords, at page 14.
Committed an error of record while concluding that the appellant had failed to bring on record the option form submitted by her on 11/8/2010 and dismissed the writ petition. Full stop. On the aforesaid ground, the the appellant is assailing the order of the learned single judge passed in the writ proceeding as well as on the review application. Full stop. Next, we have perused the readings on record and the orders passed by the learned single judge in the writ proceeding as well as on the review application filed by the appellant. Full stop. We find from the order itself, order in the writ petition itself, that the learned single judge, what was page 17 of the writ petition?
Page
17 of the writ petition.
Page 17, my lord, that is the option for my lords with an undertaking.
That the learned single judge has taken note of the option form which was available at page 17 of the writ petition. First off, the submission, therefore, that the learned single judge did not notice failed to notice the option form which was there on record in the along with the writ proceeding, writ petition, is not acceptable to this court. So we find from the impugned order of the learned single judge that the learned single judge has taken into account the fact that the employees who had exercised the option that single judge has taken note of the schemes which required that the employees who exercise their option and willing to come to the OPTCL pension regulation shall deposit employees' share of Provident Fund and differential industrial gratuity already received with 9% interest up to date in the shape of account pay bank draft drawn in any nationalized bank in favor of the director bracketed F in charge IC OPTCL, or submit an affidavit / certificate regarding adjustment / retention of such amount from the pensionary benefits for availing the pensionary benefits. First off, the learned single judge noticed that there was no statement in the writ petition about the deposit of the required amount or filing of an affidavit for retention of such amount from the pensionary benefits. First off, in the absence thereof, the learned single judge declined to grant any relief to the petitioner appellant. So stop. Next. We do not find any legal infirmity in the impugned orders of learned single judge. So stop. Admittedly, the petitioner's appellant's option. Appellant had exercised the option much after the cutoff date, and further, she had not deposited the amount requisite to avail the benefit of OPTCL pension regulation, benefit under OPTCL pension regulation, nor an affidavit was filed for adjustment of amount in accordance with the regulation. So stop. Next, we do not find any such legal infirmity in the impugned orders passed by the learned single judge requiring this court's interference in an intra-court appeal. So stop. This appeal has no merit and is accordingly dismissed.
What's my appearance for the OPTCL? May kindly be.
Yes, appearance.
Item 35.
It's an appeal, my lord. The state respondent filed a lengthy counter just now in the courtroom, 103 pages counter.
All right.
In appeal, no counter is required. I will give a short note, my lord. Next week,
for the appellant informs that he has received a copy of the counter affidavit today in the courtroom, which he is required to consider and respond if respond accordingly. Stop. As requested, list this matter on when?
1 week time, 7 days, my lord.
1 week.
Item
I have
36.
filed the counter, my lord, before marriage.
36.
Item 36. First item I am for the petition matters. For the first item, in item 36, I am the petitioner matters. Appearing for the petitioner. Dear matters, the petitioner is a registered owner of a vehicle matters. He has challenged the additional fee imposed by the Annex 5 matters. This is a notification issued by the central government.
Not agenda. As Professor, your worship had directed us to distinguish between whether the additional fee is covered under the fees or not. I have gone through several judgments, but I did not get the related judgment. I need some more time to.
Several occasions they are asking for adjournment. Several adjournments have made matters. Already they have filed the counter in this case, my lords. Already there is a reply.
She is not prepared today.
Yes, my lordship.
Short.
When? Tuesday?
Your lordship.
Tuesday.
10 days.
10 days will be much. 1 week.
Yes, okay.
As requested on behalf of
Opposite party, Union of India.
opposite party number 1.
Union of India, my lords.
All the
We have
opposite-
Union
all the
of India. Does this matter on 1 week?
Union of India.
One.
Union of India, we have mentioned.
I may be, pardon your worship. Through VC, your worship. I am the petitioner in the fourth subitem from the bottom, your worship. The WPC number 34871 of 2023. The matter is not a similar one to the matter before your lordship. That may be detailed.
So it has been submitted. Next, it has been submitted by learned counsel representing the petitioner in WPC number
34871 of 2023.
34871 of 2023 that this that the dispute involved in the present case is not similar to the other cases of the batch and may be listed separately. Stop. List this. Let CWJC number so and so be not treated to be an analogous matter with this batch of writ applications. Stop. List it on 4 weeks. 4 weeks, after 4 weeks, it will
Much obliged.
list WP number so and so, 4 weeks.
Item 37.
I mean, pardon, different councils are acting in different other cases. We'll give the list. Obliged.
The Lordship may fix next week, my lords.
Next week, Tuesday.
Obliged.
In item 37, my lord, may I pray this matter may be taken up tomorrow or any day next week, my lord?
Tomorrow,
My lord.
as requested on behalf of the
State, my lord.
state appellant.
My lord.
Appellant, list this matter tomorrow.
Item 38.
I am for the opposite party. Pray for next week.
Yes.
Item 38, I pray for next week. I am for the opposite party minor, pray for next week. And Lawrence Senior is a bit sir.
Seek his consent. Have you taken his consent? As requested on behalf of the opposite respondents. Is this matter on 1 week? Spoken for 10 days. 10 days.
Item 39.
Urgency, that's right. Urgency is 1 week.
Yes, because
1 week. All right.
I'm not getting, my client is not getting the substance and allowance.
Subsistence allowance, why is not getting? You are under suspension.
Yes, that suspension is illegal because that is also without jurisdiction. That is my case.
Private college.
But even if
Private college.
again,
Aided.
aided. But even if that I am not entitled to this suspension around, that is not been paid.
Why are you not paying?
I am not man. I am one of the
He's a private
private staff man. I am also staff.
State is the
Who has to pay? Subsistence allowance you are not paying.
Yes, sir.
no.
Not paid. I'll take instruction on that
nothing
one.
is
Not, I'll take instruction why he has not been paid.
Let the opposite respondents inform this court as to whether the appellant is getting his subsistence allowance or not during the period of his suspension.
Next week, man. Next week.
Item 39.
It is a case of pensionary benefit. The admission stays on the ground of delay. My writ petition without any adjudication is dismissed. So presently on the Supreme Court, in the case of my lord, the state of Andhra Pradesh delay, my lord, this service benefit and pensionary cannot be deferred and denied. So I pray. Only one line order, it is dismissed on the ground of delay and laches. So the Supreme Court said that in case of pensionary benefit and to claim the service benefit, delay may not be a ground.
Where is the order?
My lord, order, page 11, my lord, of the writ appeal.
No, but let there be a Supreme Court's decision, but according to you, you wanted to include period from 81 to 88.
It
And
was
you filed
decided.
a writ petition in
My lord,
2022.
No, after this judgment. So the judgment of the annual court 2022. So after the issue involving, it was decided in 2022, the non-formal service from the period from so and so, it will be counted as qualifying service. So by citing this judgment of the annual court, my
You
co-pensioners.
were fence sitter.
No, my lord.
You are sitting at the fence to look at another case.
No, my
and,
lord. By
after that
citing,
judgment is
by
pronounced,
citing
you
the
have come
judgments, by citing the presently the co-pensioners, they have represented to the government and their cases are under consideration. So as my case is dismissed on my threshold, my case is not considered. So similarly, similar situated my lord employees by virtue of this annual court presently. So
So
their
we can observe
cases are
that.
concerned. So my
If they are
case,
considering, we can observe that we will not interfere with the order.
so I pray my representation be again considered in the light of this judgment.
We will not say, just a minute.
My lord.
How much? That is
68 days, of course.
the limitation, IA number so and so. The limitation in referring the present intra-court appeal is controlled. What's up? Next, the petitioner, the appellant, and approached this court by filing a writ petition giving rise to WPC number 28933 of 2022, seeking direction to the respondents to include the non-formal service
Non-formal service.
non-formal service from 1981 to 1988 towards qualifying service for the purpose of pension and other retirement benefits. So stop. As the writ petition was filed, the said writ petition has been dismissed on the ground of delay and laches. Stop. Next, learned counsel appearing on behalf of the appellant has submitted that subsequent to that, in the light of certain decisions of this court, the period of non-formal service is being counted for considering entitlement of pension and pensionary benefits. Full stop. He submits that in the absence of any observation by this court, the petitioner's case for inclusion of informal service may not be considered because of the dismissal of the writ petition, though the respondents are considering cases of similarly circumstanced employees. So next, after having gone through the order passed by the learned single judge, we are of the view that
as the court's opinion on the merit of the petitioner's claim for inclusion of
Item 40 on behalf of Mr. Nanda, my lord, taken up 1 week after.
Lordship, I'm appealing for respondent number 5, which is twice earlier they have taken time. I respectfully submit a last date may be given to them so that the delaying tactics will be applied to them.
why this tactics?
No, that is not practice, but this is illness.
Lordship,
Who is it?
Mr. Nanda, GK Nanda. Taken up next week. Any day.
Lordship, twice earlier they have taken time to file their counter. Till date they have not filed their counter.
No, there is not stay order is not.
Lordship, stay order is there. Stay order is there. That is my
Next week, any date as your lordship pleased.
By way of last indulgence, the matter is adjourned to 1 week at the request of learned counsel for the appellant.
Petitioner.
Appellant. Stop. The interim order shall continue in the meanwhile. Stop. It is made clear that if any further adjournment is sought on behalf of the appellant, the interim order shall stand vacated.
Till date interim order.
Till date interim order, thereafter vacated. Yes. One week.
Item 41.
May I please your lordship? I find that the counsel for the respondent number 1 is not present. The case, my lords.
Who is not present?
The counsel for the respondent number 1,
Whose
Odisha
action is being
Legislative
challenged?
Assembly, is being represented through.
And who are representing whom?
I am representing the appellant.
I am for respondent number 2 and 3, ma'am. There are 3 respondents. Respondent number 1 is the Odisha Legislative.
No, but he is a necessary party.
It's a necessary party, and in fact, it is their records on the basis of which a decision has been taken.
There is no representation on behalf of the respondent number 1. Stop. 1 week or before that?
Before that, my lord, because what has happened?
Please this matter tomorrow. Please inform us.
Obliged. I'll
Learned counsel for counsel and learned senior counsel are present.
Item 42.
In item 42, Mr. R.N. Mishra, as you will conduct this case, may I prep tomorrow?
Tomorrow, as requested on behalf of the appellant.
Item number 43.
Please, my lords. Lords, before petitioner, before lordship is an educational institution, Lord, his personal bank accounts have been attached, Lord, by the EPF authorities for alleged non-payment of the dues of the EPF, Lord, EPF dues, Lord. And Lord, he approached the.
Must be having alternative remedy.
Pardon, Lord?
Must be having alternative remedy, Mr.
No, my lord. That I say, my lord. The order is without jurisdiction. If it is without jurisdiction, my lord, even if alternative remedy is available, this writ court can exercise the jurisdiction. My lord, I am armed with 2-3 decisions, my lord.
So what is the order?
My lord, order is, my lord, my only point before the honorable single judge and before your lordship, my lord, these educational institutions are exempted from the EPF purviews, my lord. Your lordship may kindly see section 16 of that.
Institution.
Section
Which educational institution is exempted?
Lord, section 16, my lord, of the Employees Provident Fund and Miscellaneous Provisions.
Let us see.
Lordship, kindly see the counter-affidavit, my lord. In
Just a minute. Where is the order?
Order on page 58. Page 58.
Yes.
My lord, your lordship may kindly see page 16 of the, section 16 of the act, my lord. Lord, section 16B, I am coming within the purview of section 16(1)B.
When did you file the writ petition?
My lord, I filed the writ petition, my lord, in the month of, my lord, July 2023, my lord.
July 2023.
Yes, my lord.
So had you gone to the appellate authority, probably appellate authority would have granted you all the relief which you are
No, no,
seeking here.
kindly see this section 16, my lord.
Yes.
Lord, section 16 says, this act shall not apply. Lord A, I am not coming. Lord B, to any other establishment belonging to or under the control of central government or a state government and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central or the state government governing the such benefits. Lord, this is an aided educational institution. This is an aided educational institution. Government of Orissa has framed rules, my lord, for retirement dues of the, my lord, the employees of the institution.
You could have told the appellate authority.
My lord, your lordship, my lord, that is a very cumbersome procedure, my lord. Your lordship may kindly see one judgment, my lord.
This is the easiest place. High Court is the easiest place.
No, no, my lord, it is without jurisdiction. That is why, my lord, I have come. This is, my lord, I am placing that judgment, willful judgment, my lord. My lord, reported in Air 1999 Supreme Court, page 22, my lord. Willful Corporation versus registered trademarks. My lord, para 15, my lord.
Just a minute. So the establishment belongs to the state government.
My lord, it is under the control of the state government.
Under the
language is, my lord, if it is within the, my lord, if it is
how do you say that it is under the control of the
Lord, if recognition or permission is granted, my lord, as per the judgment of the Honorable Supreme Court, my lord, that judgment, that word has been defined. Lord, your lordship may kindly see these two judgments, my lord. One judgment, my lord.
Your lordship may permit me to submit. So these things will your lordship.
These
Lordship may kindly permit me to submit so that if necessary, my learned friend will argue.
if you can argue his appeal, then we will permit.
No, sorry.
My lord, your lordship may kindly come to para 29, not at page 9. In respect to the contention of the respondent, that the establishment belonging to or under the control of the central or state government, it was submitted that the establishment must be A, belonging to or B under the control of the central government or the state government. In our view, the two words used in the said section have different connotations. The word belonging to signifies ownership, that is the government owned institution would be covered under the said part. The word under control of signifies the control other than ownership, since ownership has already been covered under the word belonging to. It must be noted that the two words are separated by word or, and therefore these two words refer to mutually exclusive categories of institutions. While the institution belonging to the central government or state government would imply control of the state, but the privately owned institutions can be under the control of the government in various ways, my lord. Therefore, my respectful submission is, my lord, even though this is a private institution, this is under the control of the state government. if it is under the control of the state government, my lord, as per 16B of the 161B of the Act, my lord, this is absolutely exempted, my lord. This Act has no application. Therefore, the order is without jurisdiction. And my lord, if the order is without jurisdiction, my lord, in this case, my lord, in 99 Supreme Court, Honorable Supreme Court has said, under Article 226 of the Constitution, High Court having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and or efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed.
Mr. That law you are not required to. In fact, we have also read that, Judge.
Lord, I'm obliged, my lord.
So you are not.
I'm not.
To.
My lord, in my anxiety, my lord, I'm placing. My lord, I'm obliged, my lord.
All right. And in this case, the matter had gone from the order of the Regional Provident Fund Commissioner. This case which you are citing.
Lord,
and therefore, we are saying that if we start entertaining the appeals in a manner which you want us to do, then it will become very difficult for us to
my submission is
decide cases. What are the appellate
jurisdiction?
You can tell the appellate authority that your bar, the court is not saying that we don't have existence of alternative remedy. The question is, when should we exercise that?
That is your lordship's jurisdiction, where it is without jurisdiction. 4 contingencies have been played down. If it is total without jurisdiction, my submission is total without jurisdiction.
What is without jurisdiction?
My lord, because the Act provides, my lord, Act exempts me.
If something is required to be done in accordance with law,
my lord,
and that is not done in accordance with law,
right, my lord,
that is also without jurisdiction.
Yes, my lord.
Because the jurisdiction is to do in accordance with law.
Yes, my lord.
So every act is without jurisdiction.
No.
Therefore, every case the High Court should hear.
If it comes within the 4 corners of this section, my lord, of the Act.
Don't compel us to enter into argument.
My lord, I am submitting, my lord, I am.
Yes, we have understood your point. Please sit.
Lord, Section 16B.
Certificate proceeding. Thereafter, that.
On 16B says, wherever central government, state government pension available, there for that employee PF is not applicable. It doesn't mean that where the establishment, when the pension scheme is not there.
No, he is saying that there is a scheme for contributory pension.
No. They don't have any scheme. And all college and institutions they cover. And more important, my lord.
No. This is what has been submitted. That they have a scheme.
Your lordship kindly see the language.
Just a minute. They have a scheme for contributory provident fund.
No, they don't have any scheme for contributory provident fund.
Please, we will.
Because my lord, even if they will scheme, they will make an exemption from us under Section 17. So that scheme must be more beneficial than the scheme provided by the EPF Act. If their own scheme, that is not the case. In 2002, therefore, my lord, all these are academic because your lordship kindly see the page 27 of the brief. Page 27 and page 31. 278 orders were passed. Assessment order was passed way back in 2002 and 2005. My lord, the principal establishment participated and our authority held that it applies. Act applies to the institutions, and thereafter PF assessment was made, determination was made, and some amount was also remitted. Well, 2002 order and 2005 order were never challenged till date. And now, after so much of year, this order was passed in a stage of admission when we had not appeared. And this court, my lord, liberally said that you may prefer an appeal. Even our statute says appeal is 60 days. And another 50 days is the limitation, even a 7A order. For 2000, if you lord kindly see the page 27, my lord, page 20, my lord, has enclosed that order, 2 orders. Page 27 order, my lord, this college has participated in the enter proceedings, opportunity was afforded to them, and thereafter determination was made. Lordship, kindly see page 27 of the brief.
They are all calculations.
Yes, proceeding under Section 7A of the Employees Provident Fund Miscellaneous Act 1952. This is for a particular period from 895 to then November 2002. Lordship kindly come to the next page, page 28, second para. On 26/12/2003, your Lordship, but it ballot. On 26/12/2003, Sri Nayak appeared. He produced the records with effect from 895 to 697 in respect of both teaching and not teaching staff. On perusal of the record submitted, I found that the establishment was coverable with effect from 1/8/95, and the establishment employed more than 90% on their date. In fact, the establishment on that date employed 11 teaching staff, teaching personnel, 14 non-teaching personnel. As the establishment was set up in 1/8/92, the infancy period 3 years is to be granted, and thus these.
Mr. Counsel,
Yes,
before you
my
make
lord.
your submissions,
Yes,
we
my
make
lord.
it clear
Yes,
that section 17 will have no application.
my lord.
Section 17 will have no
No
application.
application here, no application.
Mr. Section 17 contemplates power to exempt.
Exempt, yes.
So this power to exempt will apply only if the provisions of the act apply.
Act applied.
So under section 16, if an establishment is covered by section 16, then for them no exemption will be required for sections under section
Not
17.
required. That is not covered under section 16.
Therefore, why are you referring to 17?
No, because my learned friend say that we have a scheme that is the, I never referred to section 17.
Pardon.
Therefore, my these order, Lordship kindly see.
State government can say whether rule is there or not. Lord, I am not framing that. I am coming under the
These
rules of the state government.
This determination
State government will not provide
This
the
is my
pension.
earnest request to all of you that when someone is on legs and making submissions, please don't interrupt. Come on.